Maria?
We are live to be.
Mais c'est ce que je cherche aussi. Merci.
Okay, welcome to this seminar conference on algorithmic management and collective bargaining. I'm Philippe Pochet, I'm the General Director of the Institute, and I will briefly introduce the topic and the goal, and then Valerio will continue this short introduction. This project has a long history because we started to discuss this project with Valerio, I'd say perhaps 1 year ago, to say that we should do something and we should go deeper in the understanding of what is happening with the algorithmic management and the collective bargaining. And we had the idea that to have a good research, it's interesting to speak and to ask to the actor what they are doing, how they perceive the problem, what are the solutions they have found and not found at national level. And that's the idea, the basic idea of this seminar is to have a kind of exchange between research and practitioner, trade unionists, having experience in their country. And as we know, there is a difference between the country, the different experience, the trade unions are involved differently. And that's a debate which is rather new for the trade union. And that's important that we address that now. But instead of saying, I think that what we all know, what the algorithms are doing now in the selection, the evaluation, or the firing of the worker, I would like to put that in a perspective that could be right or wrong, but I think it's important to have a perspective and time perspective. And for that, I will use the approach of Carlota Perez. And Carlota Perez is a specialist of technological or industrial revolution. And she sees in all the revolution different phase. In the first phase is the emerge. And then you have the second phase.
Let's say you do it without your camera.
The second phase is blossoming, when you have a lot of...
There's no time to change now.
Yes,
Somebody has to switch off their...
Yeah. And the second one is blossoming, when you have plenty of new application, and then you have a financial crisis, then you have stabilization, and then you have growth. And I think that if we take that, the artificial intelligence and algorithm in that perspective, and the previous revolution was the computer, and now and all the system that we have, the innovation that we have now that are connecting, and that's kind of something that is emerging. So if we speak about this problem, if we speak about this question, it's not that we are speaking on something which is stabilized and that we know what are the future. Is the first trace, if we agree with this approach, of something that could have much more implication in the coming years and coming decades. And that's why I think it will be a long journey from academic and practitioner trading, so everyone, to understand in different steps what are the challenges and to be able to address them. So it's not in a way that we have a problem and it will be easy to fix. We have a problem, we will try to fix, but the problem will evolve because the technology will evolve if the scheme of Carlota Perez is right. And I'm rather convinced, and you put that on Google and you find the reference that is the right approach. So this event, and I stop with that, and once again, I thank Valerio for all the KUL for all the effort they put in this seminar. It's not the end of the journey, it's really the beginning of a long journey, how to control these new waves of innovation. So thank you, and Valerio, the floor is yours.
Thank you. Thank you very much, Philippe. Thank you for all your help in organizing this this seminar and your generosity in this. I just want to say a few words before we start with the first session to explain what this is on our side, on the academic side. We know that algorithmic management is spreading everywhere in the world of work. It's spreading for blue-collar workers, it's spreading for white-collar workers. It is used in hiring people, it is used in directing people. Imagine the famous the Amazon warehouses, the platform workers that are directed by wearable devices to their next task, to their next job. But also is used to monitor people extensively from remote through, again, GPS devices, but also through devices that track every move of the worker, every action that they do on their keyboard, every second they are in front of a camera, also using fallacious technologies, including forms of facial scanning that tries to determine their level of attention or the fact that they are saying the truth or they are lying during an interview, and things that are outright scary and that shouldn't be in place. We see this is happening again all across the economy, and we should not make the error to think that this is only a matter that regards a few workers, maybe only the platform workers that we see on our streets, or the Amazon workers that we don't see and we choose not to see. It's about office work, it's about work in any clerical occupation. Everywhere there is a computer now, there could be a tracking device that monitors how many keystrokes you've given in a certain moment of your time and takes random screenshots that then are shown to your manager. Again, big data are also used to analyze the browsing activity of workers. And all these trends were already present before the pandemic, but we saw that during the pandemic, the trends exploded. Because a lot of employers that were forced to leave people working from home because of the lockdowns didn't have the necessary experience or the necessary willingness to engage with new forms of organizations, and instead reverted to micromanagement that is basically enabled by these extremely invasive forms of control and monitoring. This raises a number of questions on the legal side. Of course, I'm a lawyer, so I'm particularly interested in that. one error that we shouldn't do is to only think that this is about privacy. Of course, all these systems can be extremely invasive for privacy, but they raise fundamental challenges to many other rights, starting with occupational health and safety, because the increased amount of control also augments stress and psychosocial risk for workers. And this is something that for the moment has been silent in the policy debate and in literature in most of the cases. It also raises fundamental questions of non-discrimination, because many of these systems are directed at a very standard worker. Basically, everyone who is not white, not a male, not in their prime age, can see the reliability of all these systems dropped dramatically, and can be damaged by the operation of systems that are not unbiased, that they are in some cases even more biased than the human managers that they plan to replace. And this is another thing that is essential to address at the from the anti-discriminatory perspective. And then, of course, we saw that these systems in some jurisdictions are also used to union bust, to collect data about prospective organization, to freeze organization, to retaliate against people that want to organize in unions or engage in any collective activity. So all these systems augment, enhance the managerial prerogatives and powers of employers in ways that are completely unheard of, and that we haven't experienced in the past. This is why collective bargaining comes to play. Collective bargaining is still the most effective and reliable way to govern and to limit managerial prerogatives of employers, and to bring them to reason, to bring these managerial prerogatives to reason, to avoid abuses. It is essential that collective bargaining is put in the loop to decide whether certain systems should be introduced at all and how they should be used. And of course, legislation can play an important role in fostering this role for collective bargaining. And this is also why it is essential to understand what national trade union movements are doing about it, how they are reacting to the challenges that algorithmic management is presenting. And it is essential that the role of collective bargaining in governing these processes is enhanced. As you all know, there are a number of initiatives, of policy initiatives, both at the national and at the European level, that are addressing some of these issues. This is only, of course, my personal opinion, but what we are seeing for the moment is that these initiatives are not correctly including collective bargaining in the loop. Even the ones that seem the most advanced, they don't assign a role to trade unions to govern the introduction and the management of technologies at the same level with employers. And this is something that can create a number of problems down the road. We should take into account that all the systems that we are putting together in our workplaces today will have effects that will last for decades. So what we are doing, or what we are about to see, it's really a constitutional process. And this is therefore extremely important that the essential role of collective bargaining in governing managerial prerogatives and business organization is also recognized when it comes to algorithmic management. So this is what we want to do today, to hear from trade unions about their ideas on these topics and what are the strategies, what are their directions, and what do they foresee is coming from their side. We can directly start with our first session that I will share, and we have 3 representatives from 3 European trade unions that I will introduce in a moment. But before that, I just want to say that, of course, this conference is also being recorded. There is interpretation in place, so you can look for the language that you want to choose, and basically you can also listen to the interpretation of this conference. You are allowed, of course, and you are encouraged, not only allowed, to send us questions for our speakers. Please use the question and answer box for doing that. Don't use the chat, use the Q&A to do that. And please make sure that you translate, or you try to translate your question in English, maybe using even an automatic translator, because there is no interpretation of the Q&A. Having said that, let's go to the first session of today. As I said, we have 3 trade union representatives from European movements. The first one that is on the agenda is Linda Larson from LO Sweden. I want to thank Linda for being with us today. Linda, you have the floor. Every speaker has 15 minutes, and then I will act as a discussant, and I will open the floor for the Q&A. Linda, you have the floor. Thank you very much.
Thank you, Valerio, so much. And I fear I have to start with apologizing for you probably not being able to see me. I don't know what happened, but right before everything started, my camera froze, and I fear I have not been able to make myself be visible to you all. But so great apologies for that. Yeah, firsthand, I really want to say thank you. Thank you for this invitation and being able to participate, and for organizing this event. Obviously, this is, as we already talked about, a big theme and a real challenge for the trade union movement, and for good work as such. And I want to try and share some of the examples of the tools that we have in our trade union toolbox. We don't have any specific tools regarding algorithmic management, meaning regulatory wise yet. What we have is general measures and tools. This is what we use right now. So I'm going to try and give you a broad picture of that. I also want to say that the Swedish Trade Union Confederation, LO, we are our member organizations. They organize blue-collar workers. So it's mainly from this perspective that I'm going to talk from. So it's good for you to keep that in mind. And as previous speakers already stated, digital system, we have had them in our labor market for not centuries, but decades. Centuries is obviously not correct, but decades, and also algorithmic management systems. But we have never really had this big discussion and debate on the effects of these systems. I think that since the debate started in Europe, obviously a couple of years ago, and also due to the COVID crisis, we have also seen some downsides of when the digital systems being used in the workplace have been misused. And so obviously this has led to big discussions among the trade unions also in Sweden. And but going into the tools that we have so far, with that being said, I just want to state that I would say that we are in a sort of a point now where we are really looking into what is happening in the labor market, trying to analyze and think through the tools that we have. Are they enough? We're sort of assessing the tools that we have. Are they enough? And also, what do we need moving forward? But our general tools that we have in our toolbox that are very useful and that we had for decades actually are the ones I'm going to present to you. And I'm not going to go into more specific regulation about discrimination and such, but usually in this context, GDPR is of course something that we will share. And I think that from our perspective, it has not been explored enough. I think we have a lot of work to do when it comes to exploring, especially the boundaries of GDPR and what it could do for us as worker representatives. But another national act that we do have is our Employment Act, our Co-Determination Act. And it's been around since the 70s, and it has given us a platform to interact with employers whenever there's activities regarding change, significant change in the workplace. There is supposed to be information, consultation, of course, negotiations around these changes. And this has sort of been our platform for discussing change in the workplace in general. That is also combined with our regulations and acts regarding the work environment. Here we also have rights to information when a working life is changing or the working place is changing. And I think these are two tools that are great. But we also see, and this is a problem that in our trade unions report, that sadly, when digital systems in general are being introduced in the workplace, these tools are not being used as they should. They are sometimes a bit forgotten, and they're used when the system is gonna come in place. They are not used beforehand so that the workers properly could be involved in the pre-analysis and risk management and risk assessment and everything as they should. So here is a big room for improvement, I think, when it comes to actually using the tools that we already have, and also remembering or reminding our employers the tools that are there for us to do this in a fair way. Yes, so that is sort of the two like good cornerstones for this kind of work. But I also want to mention that another big important cornerstone is actually the local trade union strategies that you have at the workplace. And just to take a very, very simple example, a workers' representative at a order picking, a workplace where they use the order picking system, pick by voice, which is an algorithmic management system, and they have had that system for over a decade now. We discussed how I mean, there are so many aspects to this of how it is working through such a system and the effects of it. But we also discussed the local strategies, because obviously, as we know, these systems are very, very easy to use as real-time monitoring if you would like as an employer, and how to prevent that from actually happening. And so this representative told me about very simple trade union strategies, as if someone went on a break and when they came back, the manager might come and say, so hey, I see here that there is 7 minutes where you haven't been active in the work schedule or in the workflow. Where were you? What are you doing? Instead of starting to excuse yourself, you just post a question back saying, well, how come you know this? So sort of putting the ball back in the employer's court of questioning why this information is used against you in the first place. And it might seem very silly and very easy, but these are the small effective ways they have started to use in their workplace, just to actually to get the employer to not start to misuse the technique in ways that are they're not supposed to. And obviously, being a watchdog is not always fun, but I guess this is the way of the trade union representatives, and it can also be an even more banal ways of actually encouraging your co-workers to take the small break, to encourage them to actually go on a break, regardless of the fact that they are gone and there might be questions asked afterwards, especially newcomers and young people who might not feel that it's so easy to go on a break. So with that being said, simple local trade union strategies should not be forgotten. These are the tricks of the trade that are just as important now as it has been. Another tool that we have and that I want to mention as well is that we have organization that is owned by the social partners in Sweden. This organization, actually we have two, it's one for the public sector and one for the private sector. And this is an organization that is there to inform about work environment issues and also the health and safety at work. So this is a platform that is mutually owned, that produces information, good toolboxes, and also education for both employers and employees. And of course, they also have a toolbox on digital work environment, which is also very, very helpful. We have a second mutually owned organization as well, that are between the partners, the social partners, that I also want to mention. And this is the AFA Insurance. This is our insurance organization that is linked to the insurances that we have mutual together with our collective, that is has to do with our collective agreements. But they don't just handle the insurances, they also have a research part of their organization. And it means that they give grants to researchers for research connected to working life. And so obviously we as partners are sitting there and helping to evaluate these research programs for the grants. And this is also a very good way for us to gain insights, especially through research that are more pinpointed to our needs. And now we have at least two research programs, one more connected to health and safety issues for people working through platforms, but also one that is specifically looking at algorithmic management and what it does to the people working, focusing on the health and safety issues of it, which is very interesting because this is the approach that we have been taking so far. For us now, we are sort of we have taken sort of an inductive approach, you could say, where we try to look at examples in our work life, in our sectors, different sectors, and see what is the problem connected to algorithmic management. What is the issues that we need to solve? We look at our tools. Are our tools that we have in place already enough? What do we need else? And then take steps forward. So this is where we are right now, and that's also why the international discussion on how to regulate algorithms as such is very interesting to us. So I think I will stop there, and once again I apologize for not having a camera on. Thank you.
Thank you very much, Linda. And this was indeed excellent. We already have a number of questions for you in the Q&A that I will post later during the general discussion. But then first, let's move to the next speaker, Mary Towers from the TUC in the United Kingdom. Mary, thank you all. Thank you also to you for being here with us today. Thanks a lot. The floor is yours.
Thank you, Valerio. Thanks so much. I'm just going to share my screen and hopefully it will work, but please let me know if it doesn't. Can you see that, Valerio?
Yes, I can.
Okay, great. I'll just put it into slideshow mode. Okay. So firstly, just thank you so much to the ETUI and KU Leuven for arranging this really timely conference and for extending the invitation to the TUC to contribute. For those of you who are unfamiliar with the TUC, we're a UK union confederation, and we represent about 50 different UK trade unions. And I'm an employment rights policy officer at the TUC. I propose to address the following in my presentation today. So firstly, an explanation of the TUC's AI project by way of introduction to the UK trade union approach to algorithmic management. And then a very brief outline of some relevant UK legislation and the gaps in the law and guidance, some insights into the UK union experience of algorithmic management and collective bargaining, both some general insights and some case studies. And then closing with some other steps that we found that unions can take to address the harms associated with algorithmic management. So starting with the TUC's AI project, supported by a working group of UK union representatives and some international sister union confederations, I've been leading for the past couple of years on a project at the UK TUC looking at the use of artificial intelligence in the employment relationship. And this project has had 4 phases to date. Firstly, we undertook a research stage in which we investigated the types of technologies being used to recruit and manage people at work in the UK and the impact on workers. And we found that the use of AI features across all stages of the employment relationship, from hiring across aspects of line management, disciplinary capability procedures, performance, productivity management, all the way through to termination of employment. And we also found evidence of the use of these technologies across many sectors, certainly way beyond the ambit of just the so-called gig economy. And we established evidence of negative impact on equalities, fairness, physical and mental health, human engagement and agency, privacy, work-home boundaries, a lack of transparency and explainability, and inability to challenge decisions made by technology, and many other issues which Valerio also touched on in his introduction. And we then commissioned a legal report from 2 UK lawyers, Robin Allen QC and Dee Masters, that sets out the existing relevant legal framework in the UK, identifies some of the gaps in the law and makes proposals for how to fill these gaps. And based on the findings of this report, we published our manifesto for change, with recommendations for legislative reform, additional guidance and other measures. And the final stage of our project has been to focus on guidance for union reps. We've published a basic guide on union action, as well as a webinar in which 3 union reps from CWU Unite and CCOO spoke about their experiences of collective bargaining, AI and new technologies. And all of these reports and our webinar are up on our website, and the link's there at the bottom of the slide. And this project essentially informs my contributions to the conference today. So I'll start with a brief outline of the existing legal provisions in the UK and some of the gaps in these. Firstly, the UK national AI strategy. So in the UK, the current position is that we don't have any legislation that is specific to the use of algorithmic management or more general use of AI. There's no equivalent to the EU AI Act in the pipeline. The UK government published its national AI strategy in September 2021, and this is a 10-year plan with broad proposals relating to investment, securing an AI-enabled economy, and also good governance and regulation of AI technologies. And in relation to this latter bit, good governance and regulation, an AI white paper is due to be published this year by the UK government, but it's not clear yet whether there'll be any proposals specific to the employment context. For now, we do know that the government already has a focus on the use of standards to shape AI use, because the national strategy committed to an AI standards hub pilot and the development of an AI technical standards engagement toolkit. And we also know that the UK government will approach data as a key topic. They've already consulted on reform of the UK GDPR, with significant dilution of rights proposed. For example, removal of Article 22, high fees for data subject access requests, and the removal of data protection impact assessments. And this all suggests that the UK may follow a deregulatory light touch approach to governance and regulation of AI at work. But whilst we don't have AI specific legislation, we do have existing elements of our common law and employment laws that are relevant when algorithmic management goes wrong. So just to run through a few of these very quickly, there's a duty of trust and confidence under UK common law, trust and confidence in the employment relationship. And this may assist with requirements, for example, for transparency and explainability of technological decision making. The Equality Act 2010 sets out the right to work without discrimination for all those with protected characteristics such as race, sex, age, disability, and these can provide protection against discriminatory algorithms. And then the UK GDPR, as you'll all be familiar with, has several provisions of direct relevance, such as the protections under Articles 21 and 22 relating to automated decision making, the requirements for lawful processing and for consultation mechanisms such as data protection impact assessments. And then, of course, there's the human rights aspect, Article 8 of the European Convention of Human Rights, providing some useful privacy protections. And we also have health and safety legislation in the UK that can be of use. And then in terms of collective consultation rights, the information and consultation of employee regulations were retained post-Brexit, and they give rise to information and consultation requirements relating to changes to contracts, work organisation redundancies, and other issues that are potentially relevant to algorithmic management. However, these regulations don't require a works council or a similar forum for worker representatives, and the absence of a forum of this type to discuss and decide on technological developments at work potentially stifles active and meaningful consultation in this area. In terms of the gaps in the law and guidance in our manifesto, well, in our manifesto, we identify gaps in the provisions and make suggestions for how they can be filled using legislative amendments and additional guidance. And this includes, for example, proposals to improve trade union consultation, the right to human review, secure a right to human engagement, improve rights to transparency and explainability, and also routing liability for discrimination all the way up the AI value chain. Given the urgency of the issues at hand, our strategy has been to work with what we have, suggesting a pragmatic set of proposals that could be implemented quickly. For example, there's a possible employment bill proposed for this year in the UK, and this could be used to update digital rights. However, regulation and guidance is only one part of the picture, and underpinning all of our work is the proposition that collective bargaining is the ideal vehicle to counter many of the harms associated with algorithmic management and ensure that worker and union interests are taken into account and provide for sector-specific issues and technologies. And so, having looked at national legislation, I'm now going to move on to collective bargaining and algorithmic management in the UK. In the UK, several affiliate unions to the TUC have secured provisions on algorithmic management in collective agreements, and I'll take you through some specific case studies and examples. But before I do that, I thought it might be helpful just to give a few general insights into UK union reps' experience of negotiating around these issues. So firstly, the general approach. Our unions report that they see algorithmic management as new technology presenting the same old problems relating to exploitation, unrealistic productivity targets, suppression of wages, intense management oversight, insecure work, and attacks on collectivism. And therefore, they're using long-established principles as a way to contain algorithmic management. For example, the concept of a fair day's work for a fair day's pay as a way to contain unrealistic productivity targets, agreeing fair and just productivity measures and sensible limits on working hours. And also using terms established in previous waves of new technology at work, such as the right to trial, and adapting them to the challenges posed by algorithmic management. For example, re-triggering the right to trial if an AI-powered platform is being used for purposes beyond those originally agreed. But there is also an acknowledgement amongst our reps that algorithmic management poses some new and unique challenges, in particular in relation to the disruption of human relationships, communication, and collectivism. And in addition, the pace of technological change is such that they're finding it's vital to secure provisions in agreements that anticipate technological change and are flexible enough to account for this. And secondly, data. As data is essentially the foundation for AI, it simply isn't possible to negotiate about algorithmic management without negotiating about data. And therefore, we're finding that data is the cornerstone of UK union negotiations on algorithmic management. And several of our unions are conducting training programs on data protection rights, negotiating around data, and how to ensure greater knowledge about personal data at work and more control over this for workers. And then new structures, frameworks, and roles. So we're finding that the challenges posed by new data-driven technologies are giving rise to the need for new structures and frameworks and roles for the purposes of meaningful consultation and negotiation at work. For example, in relation to data, the UK's Ada Lovelace Institute has recently published a framework for participatory data stewardship, which involves 5 different stages. And 2 of our affiliates, Prospect and Community, have both very recently published comprehensive guidance on technology at work, making proposals for the use of technology forums and technology reps, tasked with investigation, assessment, consultation, and action plans on new technology at work. There are also proposals for algorithmic impact assessments from organisations in the UK, such as the Institute for the Future of Work and the Ada Lovelace Institute. And some of our unions suggest that technology forums could be used to facilitate assessment procedures of this type, identifying the impact of algorithms at work and ensuring that they're subject to scrutiny and comment. And technology forums could therefore be the basis from which workers could be consulted on and influence all stages of the AI value chain. And community unions guidance focuses on the use of technology agreements with provisions relating to all of these new structures and roles. For example, commitments to consult, creating technology forums and working groups for specific issues, as well as assessment processes. So having looked at these more general issues, I'm just going to mention a few specific collective bargaining case studies. So firstly, CWU, their framework agreement with the Royal Mail Group, this built on a collective agreement from 2018, which dealt with the use of technologies such as CCTV and tracking tech in vehicles. And CWU negotiated the following terms with direct relevance to algorithmic management. So firstly, a commitment that technology will not be used to dehumanize the workplace, and that the key decision makers are managers and representatives, not technology. A commitment to respect for privacy and mutual trust and confidence, a right to trial before deployment of new technology, an agreed measure of productivity so that this isn't tech-driven, and that technology will only be used to complement and inform alongside existing structures, such as conversations between managers, union reps and workers, and existing human resource processes. And also that all data will be used in accordance with existing data policies and the UK GDPR. And then Unite negotiated an agreement relating to the use of Green Road, which is a driver performance monitoring programme for bus drivers. And it's based on a traffic light system with red signals on the driver dashboard signifying driver errors. And Unite reps negotiated terms of an agreement to the effect that Green Road could not be used for disciplinary matters unless there was a serious incident or accident. And they secured a right to 3 touchpoint conversations to ensure human oversight, as well as a right to training before any disciplinary measures. And then the Workforce Partnership Council in Wales, this is comprised of representatives from trade unions, the Welsh Government and public service employers in Wales, and they look at public service workforce matters. They have a partnership and managing change agreement with an annex on digitalisation, and this sets out the importance of employee voice and participation, regular and structured meetings with trade unions to look at the introduction of new technologies in the workplace and the impact on health, safety, and also workers' rights. And specifically in relation to data, just a couple of examples. Prospect members at BT Group have established a data rights subcommittee to look at data-driven processes and technologies being introduced at work. And at Northumbrian Water, unions negotiated a term in an agreement, which meant that when the employer introduced vehicle monitoring and telematics, in exchange, the drivers got an app that gave them reciprocal access to their driving data. Having given some specific examples of collective agreements in the UK, I'd like to close by highlighting just a few other potential union action points that we've identified that could be used to address algorithmic management and the potential harms of this. So firstly, and some of these I have touched on briefly already, but unions have a very important role to play in finding out what technology is being used, how it operates, and what the impacts are on workers. So undertaking investigation. And then in terms of consultation, participating in consultation at the development, procurement, and application stages of the AI value chain is key. Unions can also hold employers to account by highlighting their legal and best practice obligations, for example, in relation to worker consent, data protection, and health and safety and equality requirements. And of course, unions can provide timely legal advice and assistance to their members if they've been subject to unfairness by an AI system, in order that workers can potentially access compensation or other forms of redress. And then I've also mentioned assessment processes, so existing assessment processes in terms of data protection impact assessments, quality impact assessments, but unions could also develop expertise specifically in algorithmic impact assessments, as well as potentially influence AI standards through work with national standards bodies, such as the BSI in the UK. And then finally, perhaps consider developing AI-powered tools themselves to further worker and union interests, and take on formal data management roles to help workers collectivise data. And last but not least, we can campaign for reform of legislation and guidance to ensure that workers are afforded full protection and redress. I hope you found these insights into the UK union perspective useful. And if you're interested in reading more about our work at the TUC, please do look at our reports, which are on our website, on the link that's on this slide, or do feel free to contact me directly as well. Thanks so much for listening.
Thank you very, very much, Mary, for this excellent presentation. And actually, building on what you just said, there are a number of questions in the Q&A to both you and Linda. If you could share in the chat the links to some of the materials that you have mentioned. So if you can have a look at the Q&A, both you and Linda, and see what you can already share, it will be, I think, extremely interesting for our audience. And now the third presentation, and this presentation is from Barbara Mikowska from Solidarność in Poland, and she is actually in person present in Brussels, so she's the only one person present in Brussels. Barbara, you have the floor. Thank you very much.
Okay. Hello, everybody. First of all, thank you very much for the invitation. And I think it's quite good composition of the panel, because we have two countries where collective agreements are an important feature of industrial relation. And it's good also to have the country with low coverage of collective bargaining, to have the, let's say, more whole picture of a different situation in the member states. Because as probably you know, and it's I have to say it honestly, Poland have one of the lowest coverage of workers by the collective agreements. The lowest we have only in Latvia and Lithuania. So I can't tell you that collective agreements are important instrument, but of course they are very important from trade union perspective. And this new subject, these new topics are also among the topics which are important for us. So we don't have this, let's say, cornerstone of good industrial relation and important role of collective agreements. And honestly speaking, most of the collective agreements which we have, which are on the company level, we in reality do not have any sectoral collective agreements, are dealing with, let's say, classical issue like wages or work time organization. So generally, what is lacking, it's a kind of innovation in the area of collective agreement. And of course, in the area of innovation, I have much broad concept that only things which are connected with artificial intelligence, I mean like skills, like work-life balance, or this kind of psychosocial risk. So we have rather few examples of this kind of innovation attitude to collective bargaining. So saying this, I also need to tell you about some, let's say, more optimistic issue. And of course, they are first of all connected with the implementation of European Social Agreement on digitalization, because this in Poland was quite important, let's say, process that we start. Of course, we already haven't finished it. We are in the process of dividing topics with employer organization and in the process of bilateral and tripartite dialogue in this area connected with digitalization. And part of this is also connected with algorithm management. And so this process are going. And other issue is that I'm really happy that the seminar is today, because at least I can tell that there are some visible feature in, let's say, public policy, because in Polish Parliament yesterday, so that's recently that I'm happy that I can tell it right now, the left party, which it's called Razem, together in English, proposed a project to amendment the Trade Union Act, the Article 28, which is dealing with information, to put it clearly that trade union have the right to information on the parameter of algorithmic management when this algorithmic management is influencing the decision in the area of working condition, promotion, dismiss, and so on. So I wanted to say again, this is just a proposal, and this is a proposal of opposition parties. So there will be a long process of consultation with public, with social partners, and general public consultation, and maybe in the end of this long process we will have the legislation change, but this will be the first let's say step, because so now I can't tell you that we have anything in the legislation which is connected closely or with the algorithm management in the area of working life. So not so much is going on. I don't want to make the picture more, let's say, rosy than it is in the reality, but there are some impulse. One impulse is this impulse from the European level, from the European Social Partners Agreement, and the other input you have in this parliamentary process, which I was briefly describing. So saying this, I would like to focus a little bit on a little bit more, let's say, general question, which I think that the trade union movement need to take into consideration if we want really start dealing with the algorithm management. And of course, it's mostly connected with data, because otherwise, if we don't feed algorithm management with the vast amount of data, well, it's not able to be a learning algorithm, and the crucial point is data. So the question is about ownership of data. And of course, this question of the ownership of data is much more general. It's not only the question for the trade union. This is a question of general question for the, let's say, public policy discussion, because right now we treat data as a capital, and in this system we have the free service from free data, and this is not the only possible way of thinking about the data. We can think about the data more as a labor and about individual ownership of data. And then, of course, if we go in the second direction, then there can be some general bargaining on the topic of data, not only of this data which are strictly connected with our working life, but of many data that we produce as human beings in our daily activity. And then you have absolutely, let's say, new path for, I don't know, new path for trade union, but maybe we don't even have to use the word trade union, but some other general voice, collective voice, which will be in the direction of some kind of the balance of power. So this issue of ownership of data, I think is crucial as a kind of fundamental question. But other issue is the question of privacy at the workplace level. And of course, let's say old-fashioned, maybe not old-fashioned, but the standard way of thinking about the privacy, worker privacy in the workplace as a beginning, start with the statement, which of course is true, that there's imbalance of power between the employer and the employee. And that's why privacy of employee needs some kind of special protection. And then, of course, we can see this in the legal forms. I'm not going to speak about it. There's no enough time and no need right now. But I just want to put this as a kind of maybe a little bit provocative question that in our private life, we are dealing with much bigger imbalance of power connected with our, let's say, privacy. Probably anybody who was trying to speak with the Facebook about this activation of somebody account on the Facebook really see this imbalance of power, which is much bigger imbalance of power than we can compare to any imbalance of power with even the most strict and powerful employer. With this as an example, Facebook, you don't have any kind of discussion about this activation of your account. So I'm just telling you that I'm just trying to describe, maybe this is obvious, that this imbalance of power is in much broader circumstances that only in this working environment relation. And somehow I think that we have to take this into consideration, and we have to take into consideration what people are doing, how they are open about their privacy in their other life, not working life, because we can't be a little bit schizophrenic that we want to make very much protection of the privacy of worker, and then worker stop to be working, and then he's very open about his privacy. And if we are as a society extremely open about sharing our data and information and so on, I think we should take this into consideration when we speak about workers' privacy. So I just want to indicate that I see this a kind of topics that we really need to take into consideration in a much broader sense if we want then to have the useful tools and as a trade union to deal with algorithm management. And of course, the third issue, I think that trade union really needs to think through deeply is the question of skills. Because of course, everybody will be all this discourse about upskilling, reskilling, which is connected with just transition or which is connected with technological change and all this process. So there's no need to describe this discourse because it's very visible. But I think there is more basic question. I think that so far we speak about some kind of obligation for skilling if in the context of compulsory schooling for kids. Sometimes we speak about compulsory skilling in the sense of migration process, that somebody is compulsory to learn language or some issue connected with a country where he or she migrated. But we are not really at the moment able to agree that there is some kind of obligation of lifelong learning, not obligation on the employer side to support worker, but on the worker side to participate in lifelong learning, even when he or she is in a very, let's say, advanced moment of his or her career. So I think still without any, let's say, open question about this issue of skills and how we want to see it, and do we see obligation on employee side to participate in lifelong learning, it's quite hard to really develop this process of developing collective agreements connected with skilling. So, and again, the last of these points I'm trying to more or less clearly made is connected with, as Valerio said in his introduction, algorithm management is very much connected with psychosocial risk. But first, at least from Polish perspective, you need to make collective negotiation on psychosocial risk as such. Then you can make a collective agreement on psychosocial risk connected with algorithm management. So coming back, it's about this innovation and new topics in collective agreements. It's simply impossible to have very, let's say, old-fashioned structure of topics of collective agreements. As I said at the beginning, wages and working time, and then as a cherry on the cake, something about algorithm management. You need to have the broad scope of new topics. Otherwise, it's simply not possible to believe that collective bargaining on algorithm management will, let's say, will make a big improvement and big change on the workplace level. So I think it's a little bit like it was discussed about the COVID and the influence of COVID on collective bargaining. Because I'm working in Solidarność, as it was said, as a legal advisor, but also make some research for Eurofund. And Eurofund is asking what was the influence of COVID crisis on collective bargaining, if COVID-19 was a kind of a factor which make the renewal of collective bargaining process. And honestly speaking, I find this question a little bit naive, in the sense that somebody can believe that when you have rather crisis of collective agreements and collective negotiation, and then you have more tough situation like the COVID, that it will make a kind of improvement in collective agreements. So this kind of believing that even in the more hard situation, like in our discussion, fast speed of technological change and fast speed of new challenges, well, this is my personal point of view. I'm not so optimistic that it can be a factor of renewal of collective agreement, collective negotiation in this country, where so far the situation does not look very optimistic. Of course, I don't want to be deeply pessimistic about it, but I just want to, if I want to make this in one sentence, it would be something like, this is connected with general scope of new topics, innovation topics in collective agreement. And only if you have these new topics, algorithm management can be one of the pieces of this new broad, new topics in collective agreements. So maybe not to conclude, because it's like, it's not a conclusion, but I was really with my colleague Sławomir Adamczyk, also from the Solidarność. We were a little bit tired of industrial relation, writing about industrial relation and so on. So last year we wrote a paper about the cyborgization of working men. So I think that all really big problems are ahead of us when we will have this mind interface direct connection. And this mind interface connection is not something that is science fiction, that's something that you can find only in the science fiction books. But I think it will be the future of our, let's say, at least not more than 1 decade. Then we will really have the problem of, and big challenge of dealing with this absolutely new world of work and new features of work. So that time, probably with some kind of sentiment, we will be thinking about this kind of the challenge that we have right now with algorithm management, because I think that at that moment, when our mind will be directly connected to the software and hardware, that will be really the moment that we will feel this difference, that the world completely changed. Thank you very much.
Thank you. Thank you, Barbara. Thank you all very much for these presentations. We have many questions in the Q&A box, so I will basically waive my chair prerogatives of discuss what you all have said so far, just to give more time to the question from the audience. The only thing I think it's important to say is that, in my opinion, we should not fall in the idea that since society pushes us to give us away a lot of our rights and information when we interact with technology, this is not a good reason to basically give a free pass to employers to use this technology to monitor people and to use data to discipline them. I mean, of course, Facebook is important, but being tracked every second of your life when you are at work and being dismissed because you took a bathroom break, it's a completely different thing. So I think we should be very careful about that. Having said that, I have collected some questions from the Q&A that I'm now posing to all of you. We won't probably be able to do all of them, but let's start with 3. First of all, again, if you could explain, in your opinion, what are the main barriers that the trade unionists face in addressing algorithmic management through collective bargaining. Second, how do trade unions deal with the lack of highly specialized technical knowledge among trade unionists to deal with these issues? So the training, the possibility to have expert advice on negotiations and things like that. And also, how can unions act in situations that are outside the employment relationship or the standard employment relationship, for instance, situations in which like platform work or crowd work, in which many countries still do not recognize that platform workers are employees. So I give you back the floor. Maybe we can start again with Linda.
Yes, can I have a pick in what to answer?
Sure.
Yeah, thank you. No, but I think that the question about what or how and what to regulate in the collective agreements is, of course, the basic principle, or I mean the basic thing is obviously knowing what to regulate. And I think here we are. We're not sure at the moment for obvious reasons, and I mean there are ongoing debates on especially when it comes to the algorithms and what is essentially important to try and regulate. What kind of insights do we need? I mean, this is obviously, as we all know here, an ongoing discussion, and I think that this is probably why so few of us have taken any action, is because when we want to regulate or to negotiate something, we want to do it for the long term. Maybe we are a bit afraid of trying. I also think that there's, I mean, I know that our trade unions within our organization also often say that when they talk about these questions, it could be digitalization in general, and you know, implementation of new technologies, the employers are always not ready to have the conversation. They all are not ready to, they're really not on the train, if you understand. They're really not up to date with the themes and the big questions that need to be dealt with. So I think this is an ongoing process, and I hope that it will slowly move forward. But I think this is probably like the biggest hurdle. Yeah, thank you.
Thank you, Linda. Mary?
Thanks, Valerio. So I think that the main barrier is actually a very fundamental but quite basic one, which is a lack of awareness, a lack of understanding, and a lack of ability of all parties, really, both you know, workers and employers, to be able to communicate about the technologies. And this is a really fundamental hurdle that we all need to get over before we can even begin to progress to any of the other issues. And you know, for example, the sort of the active participatory structures that I was talking about in my presentation. I think there's some really fundamental awareness raising work to be done in terms of the types of technologies that are being used, where and how they operate and why it matters. And then on top of that, a really significant program of work in terms of training trade union reps. And in answer to one of the other questions in the chat box on that, at the TUC, we are planning some training specific to the algorithmic assessment process and backing that written guidance up with some e-learning. So that's in the pipeline. And I also just wanted to flag a couple of other things in terms of resourcing of training. So recently, an APPG in the UK, the APPG, All-Party Parliamentary Group in the UK for the Future of Work, published a report towards the end of last year that recommended a social partnership fund that could be used to support the work of groups like the TUC's AI working group to roll out training programs for reps and workers. So I just wanted to flag that, and also to flag that in German works councils, there is the ability for workers to access a technological expert that is funded by the employer. So I just wanted to flag those issues in terms of the need for training, and then, how is it resourced?
Thank you, Mary. Barbara?
I would say that it's like, first of all, there's awareness. From Polish perspective, we mostly have, let's say, information about algorithm management and problems from service sector, especially from distribution center, not so much from the manufacturer. Of course, I understand this is just the moment, it will change, but so the rising of awareness among the trade unions leaders about the issue is important factor that will improve the future possibility of dealing with this topic through collective agreements. But of course, the other problem is that there are other, let's say, issues which are seen as more, maybe not more important, but equally important and still not solved. And especially in this area of technological change, this is the question of online access to the workforce. And this online access to the workforce, especially with the connection of remote work, which was, the scale of remote work, like everyone in Poland, increasing very much, connected with COVID and all the change that the pandemic brought to us. So this is this kind of thinking, oh, we have to deal with this, we have to deal with that. And maybe the topic of our seminar today is not on the, let's say, front line of these topics. And in the situation when you have quite a lot of unsolved topics, then it's a little bit natural that you are pushing back the topics which are not so commonly raised by all, let's say, like all structure of trade union.
Thank you, Barbara. And I think I want to pose these questions to all of you, and also building on something that emerged in the Q&A. Sometimes employers basically even refuse to admit that they're using algorithmic management, and if that is the case, and your affiliates suspect instead that algorithmic management systems are in place, what to do? How do you what kind of action you think should be taken in those cases? But aside from when the employers deny that they're using these systems, even when they're using them, another thing that I think is important to address, and it's connected to the training question, it's not only that in many cases workers and their trade union reps do not have adequate training in all the technologies that are introduced at the workplace, but in many cases, even the management side, even at the employer side, there is no real awareness and understanding of what are the systems that they are putting in place in workplaces. And the reason is that many employers or managers don't produce these systems themselves. They don't have the capacity to produce or develop them in-house. They have to get them from outside their organization. And if that is the case, the kind of control that they may have on the tools that they are putting in the workplace may be close to zero. So do you think it is also time to make employers aware of the risks that they are running without even knowing, and to basically start training programs, not only for works and trade union reps, but also for the managerial side? Linda?
Yeah, but of course. And I mean, in the perfect world, we will do it together. you would do it together as you deploy. I mean, in the best of worlds, when you're gonna implement a new digital tool. I mean, obviously, you do all the work that you have to do beforehand with the risk assessment and everything. And here you obviously assess the necessity for all parties to educate themselves. And of course, if you do this through, the proper way of doing it, then you would also do it together, and you will have the knowledge. You will have the understanding of the tool. So I guess this is. This is the dream world. But I just wanted to say that and this is also very scary. I know this is obviously how it is in reality, that employers might not always have access or little to say about the systems that they have bought to use. But the problem is, and connected to the AI Act as well, is that this, when regulating especially AI systems or self-learning systems, obviously the data that is produced in the specific workplace that is used and to actually make the system work for that specific workplace. I mean, there has to be accountability for that data and that use. We can't just skip over, not when we try to regulate these kind of systems, but also not when it comes to have accountability for the system. We really, I mean, employers need to also take control over the systems. Even if they haven't produced them or made them themselves. And I think this is a huge hurdle as well to force to get the regulatory actions that acknowledges this, but also to make employers actually take this responsibility, because otherwise it's going to be very, very tough to impose any kind of good regulation or collective agreements that is connected to the workplace. Yeah. End of my little speech.
Thank you, Linda. Thanks a lot. Mary?
Yeah, one of the key findings from the research stage of our project was the importance of collaboration amongst all the different parties. So obviously workers and employers, but also crucially technologists. And so collaboration is a theme that that sort of runs through our project, and we expressed it as a key value in the value section of our manifesto. And I think from an employer perspective, certainly I know from some conversations with HR managers that they find that when they're trying to procure some of the applications, the technologists that they're working with don't really understand the nature of the employment relationship, the unique nature of that relationship, and the very particular requirements. And it's equally as difficult for employers to communicate those requirements to technologists as it is for workers and employers then to communicate about the impact of the application of the technologies. So I think that it is absolutely vital for those three groups, technologists, employers and workers. Employers and workers almost being like the dual consumer of the product in a way, that there is effective communication between those three groups. And as for how it's done, there's no reason why it should be unions that have to bear the financial and resource implications of that. It should be something, I think that a social partnership type fund that is supporting work like that across the board is a really good idea, but there's no reason why it should only be unions that bear the impact on resource of that, firstly, but also secondly, I think it is something that unions can see as an opportunity, because it's a particular area and issue which invites collaboration because of the needs of all the parties. There's a commercial interest there for the technologists to work closely with employers and with workers. And similarly, it's important for employers to be able to communicate both ways, to technology facing and worker facing. And there are great incentives for everyone to do that. So I think it's an opportunity as well as a challenge for unions.
Thank you very much, Mary. Barbara?
Answering your first question about the denying of using artificial management, most of these cases are in the process of recruitment, at least at the one that we get knowledge about. So this is quite difficult for trade union, because then we don't even have the worker, but the candidate for person applying for work, and this person have the feelings that some kind of artificial management was used for profiling or for reading the CV or any other process. And this is absolutely, let's say, at least in Poland, we don't have any regulation, we don't have any act which will stipulate that you have to get this information, access to the information that artificial management is used in doing the recruitment. So that's, from Polish perspective, is more like a legal challenge to find some kind of regulation. And answering your second question, well, it's a little bit like, because you said that somebody don't understand what is really coming out from artificial management. So the manager is saying something like outputs looks optimal, but I don't know why. But this is just what artificial learning is about. So artificial learning, by definition, is something that we will not be able to understand, in the sense that we know really why AI is making this kind of let's say, this kind of describing the situation in this way. And we still have to believe that we don't still have a strong AI. Strong AI, if you look to the books about artificial intelligence, it's very much big discussion. Maybe it will be in a decade, but you also have quite a lot of authors which telling that strong artificial intelligence is nothing that we can really predict, and it's a really science fiction story. So we are still dealing with very specialized artificial intelligence. So I think that it's quite natural that we still don't understand and feel a little bit not secure with idea of artificial learning, because this is what it's really so new for us as human beings, that something is making this thinking faster and in more broader way than we are. So nothing new to say, but probably during this panel, this seminar, we all know the story when the artificial intelligence won for the first time in the Chinese game Go, and what the feeling of the players was that they are making the moves, that the artificial intelligence is making the moves on the board, which are not, which are so strange that we couldn't feel them as a move of during the play, which human beings were possible in the position to do. So this is what artificial learning is about.
Thank you, Barbara. I think we have time for a last round of questions before going to break, to also give our interpreters a good break as well. First of all, so one general question to all of you: how do you think that fragmentation in bargaining units and fragmentation in business organization in general affects this? Does it make it more complicated for you to address the issues of algorithmic management at work? And then a specific question for Linda. Can you please share the toolbox that you mentioned that you mentioned in your presentation, if that is available? One specific question to Mary that was already in the chat is about the sometimes the gender dimension in algorithmic management, and if the TUC is addressing that specifically. And one specific question to Barbara about how to incorporate algorithmic management in the general occupational health and safety framework of protection. Thank you all very much. Linda, you have the floor.
Yes, thank you. Fragmentation, yes, obviously this is one of the core problems that we also are dealing with, and that is for the general labor market. So I think that, and I think that everyone here can agree that if you have a fragmented labor market, that it poses some fundamental problems, and obviously everything after that is going to be more difficult. And I think Barbara talked about it before as well, that that everything like health and safety obviously gets more complicated if you don't have like organized working places and stuff like that. And so of course this is that as such, and I think this is like what I'm trying to say is that when we're looking at the impact of technology, regardless of what kind of technology, the problem is that we can't only look at the problem that comes with it. We have to look at the labor market and the shapes of the labor market as such, and analyze the problems through that lens. If we don't do that, we won't get the whole picture and won't understand all the problems that we are actually facing. So yes, it is a huge problem in all ways, I would say. Yeah, and also I think that actually post links already. I think the first questions that were up in the chat, I hope that they are public. I tried to post a link for the different guides and initiatives. So I hope you will find them there. Otherwise, I will try again.
Thank you, Linda. Mary?
Yeah, on the question specific to me about the TUC's work looking at gender-based issues relating to algorithmic management. So in our project, we undertook quite general research in order to identify some quite general themes as a starting point. And so within our project, we have looked at the discriminatory impact of algorithms. And I think especially in recruitment, there's an example in our legal report looking specifically at discrimination on the grounds of sex, both direct and indirect sex discrimination. So there's that case study in our legal report. And then in our manifesto, we make a series of proposals looking at how to, I mentioned root liability for discrimination up the AI value chain. And then we've also made various recommendations in terms of there being making discriminatory data processing unlawful under the UK GDPR, and also reversing the burden of proof in discrimination claims involving the use of AI. And so that's as far as we've got on that specific issue, but there is obviously so much more to do. And funnily enough, just yesterday, I was talking with a colleague about the possibility of undertaking some research looking at the impact of women in terms of work intensification. There's been a recent drama that's based on some factual research that the BBC has produced. I'll put it in the chat, a link to it in the chat. But that drama looked at how many women undertaking warehouse work are subject to such intense productivity rates as a result of algorithmic management that pregnant women are becoming unwell and in some extreme cases even suffering miscarriages. And so we were speaking about that yesterday and about the need for some specific research into that and the impact on women of algorithmic management. So yes, there's so much more that needs to be done. Yeah.
Thank you, Mary. Barbara.
Okay. I don't want to be boring and like somehow repeat myself, but my statement is very simple. That if you don't have some good cornerstone, some good basis for collective negotiation, and some, let's say, social agreement that collective negotiation and collective agreements are important for the balance of power between the capital and labor, then it's very hard to believe that some new topics will be dealt through collective agreements. And to show what I'm trying to say, for instance, as we all know, we have now this draft of the directive on European minimum wage, and then in the Article 4, you have this idea of the promotion of collective agreement, you know, the level of people, workers who should be covered by collective agreement. And for instance, Polish government is very, let's say, reluctant to see this value in collective agreement as a tool that we can use to achieve whatever, better health and safety, you know, some other goals that we can describe. So if you don't have some kind of, let's say, social consensus that collective agreements are important, and collective negotiation are important to achieve whatever goals you can put on the list, then it's quite difficult to have a lot of hope that such issue as algorithm management will be dealt through this tool. And answering your question how to about health and safety, again, I think that the answer is pretty simple in this sense that all idea of a framework directive is about the risk assessment, to put all elements of the working environment to the risk assessment. And we know that it's just a little bit legal vision in many small and medium-sized enterprise, and not only in them. Risk assessment generally in the area of health and safety is more a theoretical issue coming from the directive than the, let's say, daily practice. So we have to improve idea that risk assessment is put this into practice in all aspects of health and safety, and then we can hope that this aspect as algorithm management will be also, let's put into this framework. This framework is not really implemented in reality. It's more like a legal framework, a theoretical framework than the framework that's really influencing many workplaces. Thank you.
Thank you, Barbara. And I think it's essential that indeed we make this work into practice and not just on books. Thank you all very much, Linda, Mary, and Barbara, for your excellent presentations and your answers to the Q&A. We now go on a break until 3:15 Brussels time. Thank you very much, and see you after the break.
There's no voice.
Not in the room. And welcome everybody who's joining us for the first time. And those of you who've come back from the previous session. And thank you to the ETUI for hosting this very topical conference, and to Valerio and Simon for organizing. I've been studying negotiations over the use of AI in the telecommunications and IT sector. This is a relatively new topic for me, but I feel like I've done a deep dive being here in Berlin in Germany for a sabbatical this year. So I'm really excited to be chairing this session. It features 3 speakers who have both national and telecommunications industry experience, which I think is maybe not a coincidence. Birte Dedden is the director of ICTS for Uni Europa. Cinzia Maiolini is director of the Office Labor 4.0 of CGIL. And Franca Salih-Madinier is National Secretary of CFDT Cadre and a member of the European Economic Committee. So after presentations by our 3 speakers, we'll have about 20 minutes for discussion. So please post your questions to the Q&A, and preferably post them in English because written comments are not translated. We will try to end by 4:20 to give the translators a break before the next session. So a little bit earlier than on the program. And I'll turn it over to you, Birte.
Yes, good afternoon, and thanks a lot, Virginia, for the introduction. And hello, everybody. I'm delighted to be here. Thanks for inviting us here on behalf of Uni Europa, where I'm the director for the ICT sector, as Virginia already said. And I'm trying to share my screen, and hopefully that will work. So just give me a moment. And here we go. And I hope this will be sharing. Yep, that looks good. Okay, great. So very quickly, I would like to talk about the role of trade unions in the whole subject of algorithmic management. We've been hearing about that already by other speakers. I just need to move slides here. Perfect. So I'm very quickly going to cover what are the challenges of algorithmic management for trade unions. Partly we've heard about that, so that'll be a short one. And then I will move more to what we have done in terms of awareness raising and training. Then I will talk about the issue of collective bargaining and EU regulation. So basically, when we talk about the challenges of algorithmic management, what do we talk about? We've already heard about CV screening, keystrokes logging, cameras, or voice or emotional analytics software that is being used. For instance, in contact centers, I can talk about that because we represent the telecoms and ICT sector, where we have a lot of people that are the subject of surveillance. And if you think about contact center workers that are in real time given feedback by a software that tells them, oh, you talk too fast, or you do not sound empathetic enough, you can imagine the stress as well that is put on people that are managed directly by an algorithm, if you like. So there are a lot of tools that are used, for instance, predictive people analytics tools combined with data mining to, for instance, predict employees' future behavior. And these are, of course, very, I would like even to say, harmful features, because these systems can really impact on workers' physical health and mental health. So we've seen a huge increase of surveillance and algorithmic management at work since the pandemic, but even before that. And there's a big variety of tools that is being used. And as I said, it has a very heavy impact on people and can create a lot of stress, but also bias. It has a big impact on privacy and these kind of things. So it's a huge issue for everybody. And also these systems bear a risk of unethical use as well. So we don't know really what justification sometimes there is why an employer uses this. It's often said it's for a productivity increase or to monitor and to improve productivity, but we're not so sure of that, to be honest. And the big issue here is actually the lack of transparency and the power imbalance that Barbara was already talking about. So we really see that many workers don't really have a clue what data is collected by the employer, what is the data that is taken, when there is a login control, etc. So we would like to have a bit more light shed on these questions. And so as we have realized that our membership is very often faced to that kind of management tool, but doesn't really know a lot about it, there's a huge need to raise the awareness of workers and to train them. So which is why we engaged in a huge campaign on awareness raising and training of affiliates. In 2019 already, and then later in 2021, we've issued a paper on the impact of AI and AM on the workplace. We've also run dedicated training webinars in 2020 and 21. And we've also been very active in terms of social partners at European level, because the committees for the insurance and the telecom sector both have drafted joint declarations on the issue of AI, including the issue of algorithmic management. So I think that is already quite a journey we've been doing here. And the objective is obviously to raise awareness among our colleagues of what is the role of social partners and especially trade unions in this, to make our voice as workers heard in the debate, both at European level, but also at national level, and really to develop AI and algorithmic management as a subject for collective bargaining. And the topics we've been, for instance, addressing in our training sessions were ethical AI, the role of social partners, but also data management, skills and training, bias, and the right to disconnect. So the most recent work we've been doing is actually a survey that we've been developing together with the Friedrich Ebert Foundation. And this is a survey on the awareness regarding algorithmic management tools at work. The survey has been run just recently in January and February. We are at the moment in the process of getting the results in, but it's very clear. And also that survey already shows the major finding that there is a huge uncertainty of people around the issue of algorithmic management and the use of these tools, and the lack of transparency has been identified as the major issue really around that. And I would like to link up to what has been said by Mary already, that unions should really get some support by technical experts to gear up the game and to really have that expertise they would really need to identify issues around algorithmic management and work. So coming to the issue of collective bargaining, it was already mentioned, and it's very nice, I can directly link up again to what Mary said, but also what Linda said, that we've seen now that algorithmic management is really a topic for collective bargaining at all levels, and social partners really have a role to play here. This is very clear, and it should be regarding the negotiation of the design, the implementation, and the governance of algorithmic management tools. So many unions have already started to provide guidance, and I would just to name but a few. Mary mentioned already Prospect, our affiliate, who has a very great guide to data protection and impact assessments. Also CFT Cadre, and Franca is going to talk about that later on, has published a guide to AI at work, but also our colleagues in Austria have done great work regarding guidance on liability and accountability. And many unions work around those issues of transparency, data protection, etc. And coming back to the survey results, as far as we can see them already, nearly half of all respondents, and we are talking about 1,400 responses to our questionnaire, 49% of these people have said that unions have started raising the issue of monitoring and surveillance in the national context. So this is great. That means that the awareness raising efforts we've been doing, and ETUI has been also very much involved in that. Big thanks also to the colleagues here. This has been starting to pay off, but we are still part of that journey. So I think there is a first step that has been taken, but we want to go further. We really want to build a collective bargaining agenda around that topic. And so what we've seen so far is there is not that many agreements yet that it really focus or that are dedicated to the issue of algorithmic management. We do have many agreements at national level that would cover bits and pieces, for instance, the right to disconnect, or for instance, data protection or employees' rights to co-decide on how new technologies will be implemented at work. We've got very interesting agreements, for instance, in Denmark, but also at Swisscom, at Orange, lots of stuff going on, but not necessarily just looking at algorithmic management in particular. However, it's clear that workers have a huge demand. They would like to know more, they would like to get more information. So really, workers expect employers to inform them and to involve them when it comes to the implementation of these tools, and also ask questions. So what are the systems you're using and how do they work? So I think this is really important, that we need to start asking questions. I think that is like a really key takeaway from what we've been discussing with our colleagues, at least. And so that leads me to the question of what will be the demands when you go and start negotiating on algorithmic management. What are the issues you would really like to talk about? And the first point would be the justification. So why? Why is data collected? To what purpose? Why is there any surveillance tools used? It should be a clearly justifiable purpose why that is used. So you should start asking those questions. Transparency is a major issue. So the employer should be obliged, we think at least, to inform and to explain and agree together with the workers on what tools are applied and how they are applied. And that leads us to survey respondents that in our case have responded with a huge majority that they really want more transparency. They also would like to have clear red lines for unethical systems that could impact on workers' health, on fundamental rights, or other issues like privacy. So I think about 70% of those colleagues who have responded to our survey have said they really would like to see very concrete and specific limits to algorithmic surveillance. So that is a very clear result. And this is very much in line with what we ask as Unieuropa at European level, because we really want a ban of, for instance, biometric facial surveillance tools, but also other harmful tools like emotional or also surveillance and prediction tools. And that leads us very quickly to the question of how can we achieve that? And the answer might even be quite simple. It's the human and command approach. That means that the algorithm can advise the decision maker, but the humans should decide and not the algorithm. So workers should always have the right to appeal to a human that is authorized to override any algorithmic decision. I think that is absolutely crucial here. And if we want to have that in place, it's also clear that we need very specific governance and accountability mechanisms involving trade unions. And I would just very quickly, obviously I'm speaking on behalf of the European Trade Union Federation, so I will have to talk very quickly about EU regulation. Just this week, we had a new report adopted by the AIDA committee. It's a dedicated committee in the European Parliament on artificial intelligence. And they also highlight some elements like the surveillance, AI-driven surveillance at work that should be rather condemned. Also the question of the protection of workers' rights and well-being, and also that employers should be transparent about the use of AI and also inform workers prior to the use of those tools. So that is very much in line with what we've been asking. Luckily so, but obviously we need more than that one report at European level to really work for workers' rights. So we've been lobbying on the EU AI Act, on the Platform Directive, etc., and we really try to contribute to all those discussions. And the key concerns we see is the involvement of social partners in the development, the deployment, and the governance of AI and algorithmic management systems. This is the crucial point, I think. And it's very important that any kind of system used in the employment context should be regarded as a high-risk tool and subject to third-party independent impact assessment. So for those who are not so familiar with the EU regulation, there's a big talk about self-certification of the industry. And obviously, this doesn't seem to be very neutral, to put it that way. So we are very much in favor of having some sort of independent control about that. And it's very important that whatever legislation is there at European level, this should definitely not undermine existing protections at national level. So if you have a good legislation, if you have good collective bargaining tools, this should definitely not be undermined by any kind of regulation. And that would be the same for any legislative directive or regulation that is put into place. And regarding the platform directive, just very quickly, we are in line with the ETUC lobbying on this, where one of the key questions is to limit the scope, yes or no, to fully automated systems. And we feel that this might be a bit too restrictive, basically. But I'm not going to go too much into detail with that, because I guess we have enough time for questions afterwards. So thank you very much for your attention.
Great, thank you, Jutta. Now over to Cinzia.
Buongiorno a tutte e a tutti. E tolgo l'interpretariato perché non ce n'è nessun bisogno. Ok. Allora, salve. Io ho ascoltato con molta attenzione tutti gli interventi precedenti e sono veramente molto contenta di avere un quadro un po' più ampio di quello che sta accadendo in Europa. Diciamo che in Italia non esiste ad oggi una legge specifica a tutela della gestione algoritmica in ambito lavorativo. Tuttavia ci risulta, pare che il Ministero competente stia proprio lavorando ad una proposta di legge sulla trasparenza della gestione algoritmica in occasione della prestazione lavorativa, dalla fase assunzionale fino all'eventuale espulsione dall'ambito lavorativo. Questo per noi è di molto interesse, aspettiamo ovviamente di capire se e quando questo testo verrà presentato. Nel frattempo però in Italia abbiamo una serie di norme. La prima è una legge del 2019, una legge sulla tutela del lavoro e delle crisi aziendali, che ha stabilito in uno dei suoi articoli chi sono i lavoratori a cui si applicano i livelli minimi di tutela, quindi un contratto scritto, un compenso orario minimo, che viene parametrato ai minimi tabellari stabiliti dai contratti collettivi nazionali di settori affini o equivalenti a quello del lavoratore in questione. Contratti che devono essere stati sottoscritti dalle organizzazioni sindacali e dalle organizzazioni datoriali più rappresentative a livello nazionale. Si tratta quindi in questo caso di lavoratori autonomi, sì, che svolgono attività generalmente di consegna di beni per conto altrui in ambito urbano, con l'ausilio di velocipedi, veicoli a motore, attraverso piattaforme anche digitali, quindi una specifica connotazione di lavoro e di lavoratore. Vengono in questo caso considerate piattaforme digitali i programmi e le procedure informatiche che il committente utilizza indipendentemente dal luogo di stabilimento e queste piattaforme devono essere strumentali per l'appunto alla consegna di beni. Quindi si è in qualche modo cercato di trovare un modo per stabilire almeno un compenso minimo per questi lavoratori e diciamo, un livello minimo equanime di diritti. Di fatto, diciamo così, al fine del riconoscimento della subordinazione oppure della discriminazione che può essere attuata dalle piattaforme, il sindacato italiano ha dovuto agire delle cause legali e facendolo ha ottenuto una serie di risultati, di sentenze, di pronunce che probabilmente sono, diciamo, anche alla base della necessità ravvisata forse anche dal governo di presentare per l'appunto una legge in materia. Ad esempio, rispetto ai riders, quindi alle piattaforme in particolare di food delivery, noi vogliamo citare la sentenza della Corte di Appello del Tribunale di Torino che nel 2019 ha cambiato, ha riformato la sentenza del giudice di primo grado che riteneva che il rapporto di lavoro che intercorre tra le parti, in caso appunto di piattaforme di food delivery, fosse inquadrabile nell'ambito della collaborazione coordinata e continuativa, quindi non ravvisava il giudice di primo grado la subordinazione. La Corte di Appello invece ha cambiato, diciamo, l'impostazione e su questo punto ha affermato che nonostante il lavoratore sia autonomo, al lavoratore andasse applicata la disciplina del rapporto di lavoro subordinato, nel senso che in questo caso si riconosce in qualche modo un vincolo di subordinazione tra la prestazione del singolo e la piattaforma che lo regolamenta, diciamo così, dall'esterno. Questo perché ovviamente vi sono delle tempistiche di lavoro rigide, delle caratteristiche del lavoro che sono molto simili a quelli del lavoro subordinato. Quindi ha provato a individuare una sorta di tertium genus, diciamo così, di modalità di prestazione di lavoro che è stato chiamato lavoro etero-organizzato. Non sei un dipendente, non sei autonomo, ma hai alcune caratteristiche del lavoratore dipendente e quindi sei un lavoratore etero-organizzato. Dopo questa sentenza, però, la Suprema Corte nel 2020 ha contestato la configurazione di questo tertium genus, di questa terza specie di possibilità di riconoscimento del lavoratore. Quindi ha previsto una tutela rafforzata nei confronti di alcune tipologie di lavoratori considerati deboli, come per l'appunto i riders. E ha poi precisato la Suprema Corte che i riders hanno in ogni caso diritto al trattamento di un contratto collettivo nazionale di lavoro specifico, che è esattamente quello della logistica e del trasporto merci, ed ha anche identificato a quale livello di inquadramento. Quindi siamo passati in qualche modo al riconoscimento per questi lavoratori di una equipollenza col lavoratore del contratto collettivo di lavoro del trasporto e delle merci. Sempre la CGIL con tre categorie, scusatemi, quindi quella dei trasporti, quella delle nuove identità del lavoro e quella del commercio, ha promosso poi una causa contro Deliveroo. Con quale motivazione? Con la motivazione che l'algoritmo che è alla base di Deliveroo, cioè l'algoritmo Frank, emargina i lavoratori che per motivi personali legati a diritti personali come la malattia, quindi diritto ad assentarsi per malattia o lo sciopero, non si rendono continuativamente disponibili al lavoro. Ecco, Frank considerava queste assenze, diciamo così, nel rating come motivi per non dare più commesse, diciamo, non chiamare più questi lavoratori. Questa causa, promossa appunto dalle categorie della CGIL, è stata accolta dal Tribunale di Bologna ed è stato riconosciuto che il sistema di Deliveroo effettivamente realizza una discriminazione indiretta e penalizza i lavoratori. Ho un ritorno in cuffia, non so per quale motivo. Abbiamo poi altre ordinanze, quindi mi sto riferendo a tutta una serie di cause, di decreti, di ordinanze dei giudici che anche in assenza di un sistema di legge chiaro hanno dovuto riconoscere dei diritti a questi lavoratori. Ad esempio, un'ordinanza di ingiunzione nei confronti di Fudigno da parte del garante della privacy. Il garante della privacy, applicando il regolamento europeo sulla privacy, ha chiaramente notificato alla società alcune violazioni. Ne cito alcune, ad esempio rispetto ai principi di liceità, ai principi di correttezza, di trasparenza, alla minimizzazione della conservazione dei dati. Quindi ha fatto un'indagine specifica il garante per capire, ma i dati di questi riders dove sono tenuti, per quanto tempo, a quale fine sono utilizzati, si assumono delle decisioni sulla base di questi dati, quindi c'è un processo automatizzato di decisione che profila il lavoratore, quindi ha sostanzialmente riscontrato e sanzionato anche la società, ha riscontrato delle violazioni in questo senso. Dunque, ripeto, in Italia non esiste ad oggi una legislazione specifica, ma il sindacato, richiamandosi a delle norme esistenti e attivando i tribunali nelle sezioni di lavoro, ha agito per riconoscimento della protezione dei rischi che deriva dalla eterodeterminazione algoritmica della prestazione dell'attività di lavoro. Ogni volta che possiamo, noi chiamiamo in causa il garante, perché ogni volta che secondo noi i dati sono utilizzati in maniera impropria, non trasparente, oppure i lavoratori non sono sufficientemente informati rispetto all'utilizzo dei propri dati, noi abbiamo l'occasione di rivolgerci al garante della privacy, che è un'autorità indipendente che applica per l'appunto il regolamento europeo. Ora è chiaro, se il tema è che cosa può fare il sindacato, ecco, il sindacato, la CGIL, ha costituito un ufficio ad hoc già nel 2016, che è quello che in questo momento io coordino, e che si occupa specificatamente appunto della digitalizzazione del mondo del lavoro. Ha fatto ricerche, ha fatto pubblicazioni, tutte collettive, cioè lavorando in gruppi, perché la digitalizzazione è per sua stessa natura trasversale, ed è arrivata alla conclusione che è necessario che si preveda negli accordi collettivi un diritto di informazione e di consultazione in capo ai rappresentanti dei lavoratori e delle lavoratrici, di modo che l'algoritmo possa essere contrattato. Del resto gli algoritmi si nutrono di dati, l'abbiamo detto tutti, e dunque anche solo il richiamo al regolamento europeo sulla privacy ci consente di estendere all'ambito lavorativo i principi richiamati dalla giurisprudenza. Ad esempio, sempre il richiamo al regolamento europeo ha fatto sì che una sentenza del Consiglio di Stato, sempre nel 2019, abbia ribadito l'esigenza di conoscibilità e comprensibilità dell'algoritmo. La conoscibilità e la trasparenza della decisione algoritmica sono elementi imprescindibili, dice il Consiglio di Stato, per la non discriminazione algoritmica. Quindi si prende atto che c'è un rischio di discriminazione algoritmica. Solo la trasparenza la evita, la può evitare. Vi è un'ordinanza della Corte di Cassazione, che per noi è la Corte Suprema, che ha confermato una relazione stretta tra algoritmi e protezione dei dati. In sostanza, l'interessato, l'interessata, quindi il lavoratore, la lavoratrice, ma anche il cittadino, devono poter conoscere la modalità di funzionamento dell'algoritmo. Questo vale per i privati, vale per i lavoratori. È chiaro che l'utilizzo della tecnologia modifica il processo, modifica il prodotto, quindi bisogna prevedere delle modificazioni anche di natura contrattuale, che richiedono un ruolo preciso del sindacato nella contrattazione nazionale, sia appunto in quella nazionale, sia in quella aziendale di secondo livello. Quando si utilizzano delle particolari soluzioni tecnologiche, di cui molti di voi hanno già parlato, ad esempio soluzioni di intelligenza artificiale, che sono in grado di impiegare una mole enorme di dati in un tempo talmente breve da candidarsi ad essere strumenti di lavoro che consentono di ridurre sensibilmente i tempi di produzione e di rendere più efficiente l'organizzazione del lavoro, le conseguenze noi le vediamo in moltissimi ambiti. Ne indico 2 o 3 per essere molto veloce. Nella fase assunzionale, l'intelligenza artificiale può produrre discriminazione nella fase assunzionale. Dipende da come sono impostati i dataset per il training della macchina, quindi che tipo di ragionamento, diciamo così, fa la macchina. Può esserci discriminazione nell'organizzazione del lavoro, come abbiamo visto, perché c'è un controllo forte della produttività del singolo, della sua performance, una profilazione forte che vale quando si valuta la produttività individuale e quindi anche eventualmente la carriera. E poi c'è un tema che attiene anche l'eventualità della profilazione del lavoratore ai fini dell'espulsione dal mondo del lavoro. Noi abbiamo molti esempi in questo campo, IKEA, Amazon, piattaforme di food delivery che hanno utilizzato meccanismi di questo sistema. E poi c'è il potere direttivo del datore di lavoro. Tutti questi aspetti riguardano il sindacato. Quindi noi vorremmo e chiediamo che nei contratti collettivi nazionali di lavoro vi sia un diritto di informazione e di consultazione dei lavoratori e la trasparenza nell'applicazione della tecnologia in quel momento implementata in azienda. Quindi noi vorremmo nella fase ex ante, cioè precedente all'applicazione, noi vorremmo conoscere quale tecnologia si applica, per quali obiettivi, come è impostato l'algoritmo, come sono impostati i dati con cui si applicherà, diciamo così, la educazione della macchina, quindi avverrà il machine learning, e vogliamo ex post, cioè dopo, valutare la corrispondenza di questi processi algoritmici con i principi sia contrattuali che normativi e anche con gli obiettivi che ci si è posti tra le parti, perché i rischi che si vede, che tutti noi abbiamo insomma dichiarato, soprattutto con l'applicazione dell'intelligenza artificiale, è che la capacità di autoapprendimento della macchina faccia sì che la stessa macchina prenda decisioni persino diverse rispetto a quello che il programmatore aveva voluto impostare. Ora, per quanto riguarda la direttiva sulle piattaforme, e vado a finire, noi sappiamo che la proposta di direttiva mira proprio a promuovere la trasparenza, l'equità e la responsabilità nella gestione algoritmica del rapporto di lavoro. Però secondo noi c'è qualche criticità anche rispetto a questa direttiva. Ad esempio, in relazione alle previsioni dell'articolo 8, noi evidenziamo che la norma sia di difficile lettura e un po' difficile da coordinarsi col nostro sistema, cioè noi pensiamo che sostanzialmente saremmo costretti a ricorrere al giudice per stabilire quando la decisione algoritmica viola i diritti del lavoratore di piattaforma. Quindi il tema è ancora un po' spinoso. Peraltro, dando per scontato che la piattaforma difficilmente tornerà sui suoi passi, è evidente che noi dovremo nuovamente ricorrere nel caso a un giudizio, al giudice, diciamo così. In secondo luogo ci sembra un po' particolare che la piattaforma non possa rettificare la propria decisione, perché questo presupporrebbe un'impossibilità materiale per la piattaforma di intervenire in una procedura algoritmica che lei stessa ha predisposto, che ha fatto predisporre, di cui ha il controllo. In ogni caso, noi abbiamo già visto la critica che la Confederazione Sindacale Europea ha fatto in merito all'articolo 9 della proposta di direttiva, che riguarda, come sappiamo, i diritti di informazione e le procedure di monitoraggio algoritmico, perché non menziona le organizzazioni sindacali. Quindi, chiudendo, Quel che noi vogliamo fare a livello Italia è quello di riconoscere, come ho già detto e ripeto, il diritto di informazione e di consultazione dei rappresentanti dei lavoratori e delle organizzazioni maggiormente rappresentative inserito all'interno dei contratti collettivi nazionali. Non si applica tecnologia senza che le organizzazioni sappiano di quale tecnologia si parla e quali sono le finalità. Dal punto di vista europeo è evidente che abbiamo bisogno di ragionare insieme anche su applicazioni attinenti, ad esempio, il sempre maggiore utilizzo di intelligenza artificiale, che ahimè non riguarda solo lavoratrici e lavoratori, ma anche comuni cittadini. Vi ringrazio per l'attenzione.
Thank you very much, Cinzia. And that was really interesting for both speakers so far. And now I'll turn it over to Franca.
Je vais parler en français. Merci beaucoup d'abord pour cette initiative et pour m'avoir invité à ce débat qui me semble important au moment où nous sommes confrontés à de plus en plus des changements et impactants pour les travailleurs tels que la technologie dont nous sommes en train de parler. Alors, d'abord, moi je suis secrétaire nationale à la CFDT cadre, CFDT qui est la première organisation syndicale en France. Je suis en charge du numérique, je m'occupe de l'Europe et des lanceurs d'alerte. Je suis aussi vice-présidente pour la CFDT au Comité économique et social européen, donc je me suis beaucoup investie au sein de ces comités dans les avis que la Commission nous a demandés et aussi sur l'intelligence artificielle où j'ai fait 2 rapports. Et donc nous avons participé aux consultations de la Commission et du Parlement sur cette question de l'intelligence artificielle. Je dirais que le comité a commencé ses travaux en 2017 et donc nous avons même initié le débat, je dirais, en Europe au sein de ces comités. Hop. Juste. Et donc, dans le cadre un peu des travaux que nous avons commencé en France au niveau de la CFDT, alors, première chose, je vais vous parler d'un contexte, je ne sais pas combien partagé dans les pays, mais le contexte en France, c'est que nous avons remarqué que les délégués syndicaux, nos délégués, nos militants, lorsqu'il s'agit de parler de ces questions, intelligence artificielle, c'est un mot qui fait peur, et pour lesquels les syndicats et les syndicalistes se sentent inappropriés ou pas même de discuter de ces choses qui sont associées à des connaissances mathématiques et tout le monde n'est pas mathématicien dans le monde syndical et donc c'est déjà un frein. Ça, c'est la première chose, ce qui fait qu'il n'y a pas eu beaucoup de dialogue social sur ces questions et encore moins des négociations et des accords. Entre-temps, nous avons vécu tous, pendant les Covid, une accélération, une diffusion énorme du télétravail et une croissance énorme de l'utilisation des logiciels intrusifs. Et par exemple, la Commission nationale informatique et liberté, qui est la commission en France qui a décliné le règlement général européen de la protection des données, pendant cette période de Covid, même maintenant, elle reçoit de plus en plus de plaintes des travailleurs qui se sentent surveillés. Donc, ça veut dire que ces outils ont été introduits sans négociation, sans consultation et sans information. Pas parce qu'il n'y a pas de loi qui oblige à ça. Mais l'autre chose que je voulais dire, me semble importante, c'est que l'intelligence artificielle, ces logiciels, se greffent sur des technologies qui existent déjà dans les entreprises. Et donc, ceci exonère les directions de dire il n'y a pas une nouvelle technologie. Nous n'avons rien introduit de nouveau. On a simplement greffé des choses sur des choses préexistantes. Et donc, même les syndicats sont très confus. Et comme ils ont peur de cette technologie et qu'ils ne se sentent pas maîtres, ils n'en discutent pas beaucoup. Et c'est pour ça que nous avons fait un groupe de travail avec des militants syndicaux, mais aussi avec des dirigeants d'entreprise, avec les représentants du gouvernement. Et à la fin de ce travail, des consultations, etc., nous avons pensé qu'il était intéressant et utile de faire un guide qui s'appelle « Les guides de l'intelligence artificielle au travail » et un sous-titre qui est quand même pas neutre, « Vos droits face aux algorithmes ». Et ce guide veut simplement démystifier les sujets et donner des clés pour dialoguer, pour discuter et pour que les syndicats soient acteurs de ces transformations. Et donc, je reviendrai sur les outils qui existent et que nous pouvons utiliser, mais aussi sur les choses que peut-être nous devons aussi améliorer par rapport au dialogue social. L'autre chose, ce guide, il est aussi disponible en anglais, en version un peu plus réduite, donc vous pouvez aussi les télécharger sur les sites du Comité économique et social européen, et donc il est accessible gratuitement. Voilà. Alors, la question aujourd'hui, c'est en France, où est-ce que l'intelligence artificielle est utilisée? Pour ce qu'on a fait au niveau syndical. Amazon, bien évidemment, les plateformes logistiques comme Amazon, Lidl, Aldi, Téléperformance, Birth l'a déjà cité, Téléperformance, c'est une entreprise française qui utilise des webcams qui surveillent les travailleurs à la maison et tous leurs gestes sont surveillés et contrôlés. Il y a aussi des applis comme Assess First, qui est utilisé pour les recrutements prédictifs. Donc, les algorithmes prédisent ou recommandent le recrutement de tels candidats. Et des entreprises comme L'Oréal, mais beaucoup d'autres qui ont beaucoup de CV, qui reçoivent des centaines de milliers de CV par an, ils sélectionnent les candidats de manière presque automatique, déjà aujourd'hui et depuis longtemps. Donc, cela, je dirais, ça échappe complètement aux négociations syndicales, même parce que c'est difficile, un candidat ne sait même pas qu'il est recruté de cette façon. Parfois, on a des suspects, il y a des jeunes qui viennent me voir, me disent, mais j'ai envoyé un CV vendredi et le samedi, j'avais une réponse, je n'étais pas retenue parce que probablement, je n'ai pas mis les mots-clés qu'il fallait mettre pour que l'algorithme sélectionne mon CV. Donc, on sait qu'il y a beaucoup d'entreprises qui utilisent les outils IA pour les recrutements. Maintenant, sur les risques, peut-être je vais évoquer des choses qui n'ont pas été dites auparavant. Nous, il nous semble qu'il y a aussi une remise en question du rôle, par exemple, du management et des managers de proximité. Parce que si c'est la machine qui décide d'un recrutement, si c'est la machine qui décide d'une promotion ou d'un accès à la formation pour un travailleur, voyez bien que les rôles même du RH, ils s'en trouvent diminués. Et d'ailleurs, nous avons travaillé au niveau CFDT avec les entreprises et on sait que les DRH subissent quelque part ces systèmes d'intelligence artificielle qui n'ont pas été annoncés non plus au management. Et donc, souvent, ces systèmes sont introduits par les experts de la maison, des directions, des entreprises, des organisations, sans forcément impliquer les acteurs, qui sont aussi côté direction. Donc, ça, il me semble que c'est important de regarder comment le travail du management, du manager, change, avec aussi des outils comme les objets connectés, mais aussi les tutoriels qui maintenant transfèrent les savoir-faire parce qu'ils forment beaucoup plus vite des nouveaux recrutés et donc l'expérimenté, les salariés expérimentés ou les chefs avant qui transmettaient les savoirs, presque n'a plus de rôle. Donc, il y a quand même une perte des savoir-faire, peut-être une certaine perte des compétences par rapport à certains métiers et aussi une crise de l'autonomie. Et là, je pense que syndicalement, nous devons être très attentifs parce qu'un algorithme ne sait pas expliquer pourquoi il décide ou il recommande telle ou telle chose. Et donc, l'algorithme ne doit pas, ou la machine ne doit pas décider. Donc, la question de la human in command, comme c'est dit au niveau européen, que l'humain doit avoir les derniers mots, ça doit être aussi un objet de négociation. L'algorithme ne peut pas décider tout seul, et quand il décide tout seul, comme il est aveugle, il produit des choses discriminantes, comme ne pas sélectionner les curriculum vitae des femmes. Amazon, en 2018, il a dû retirer son algorithme parce qu'il discriminait les femmes, ou bien Deliveroo qui a licencié un salarié parce qu'il était absent, mais il était absent pour grève, et donc il a porté atteinte à un droit fondamental qui est celui de la grève. Et donc, voilà, c'est un peu les choses qu'il faut concrétiser et comment les syndicats doivent s'approprier de ces choses-là. Après, il y a tous les risques que vous avez un peu évoqués sur la santé, mais là aussi, je pense que les syndicats sont un peu à devoir être conscients que les risques même sur la santé et sécurité sont en train de se déplacer et qu'il y a de plus en plus que des risques pour la santé mentale que ces outils produisent, l'isolement, le stress, les contrôles à 360 degrés produisent du stress et des maladies aussi, pas des maladies directement, mais quand même aussi le sens d'être isolé ou d'être même pas complètement armé vis-à-vis de ces outils. Et donc, il y a quand même un déplacement des maladies professionnelles qui ne sont pas forcément des maladies physiques, des lésions, mais des maladies plutôt d'ordre mental. Voilà, et donc ça, peut-être la santé mentale n'est pas encore un sujet sur lequel nous négocions pleinement et entièrement. Et je pense que c'est aussi ça qu'il faut un petit peu améliorer. Après, j'avais parlé donc en introduction des leviers. La collègue polonaise tout à l'heure, Barbara, a dit qu'il n'y a pas de leviers. Moi, je pense le contraire, on a des leviers. On a des leviers juridiques en France, bien évidemment, je vous en parlerai, mais aussi en Europe. Le règlement général de la protection des données, c'est un règlement européen. Il y a 2 articles, ou même 3, qui me semblent importants dans ce règlement. L'article 22, qui dit qu'un humain ne peut pas être soumis à une décision unique prise par l'algorithme. Article 22 du règlement général de la protection des données, donc il est utilisable en Europe. L'article 88 qui préconise des négociations, même des branches, pour les questions des données et données personnelles, donc les recueils, les traitements, l'utilisation, etc., qu'on a fait. Mais combien les syndicats utilisent aujourd'hui ces 2 articles? Après, il y a des articles comme l'article 40 sur les codes de conduite qui peuvent être aussi négociés peut-être ou au moins concertés avec les syndicats. Et ensuite, il y a toute la directive des comités européens, l'information, consultation. Mais il faut faire attention justement à ce que je vous ai dit précédemment. Si l'intelligence artificielle n'est pas considérée une nouvelle technologie, personne ne s'en occupe. Mais si les syndicats mettent sur la table des questions concrètes pour dire est-ce que mon entreprise, mon organisation utilise l'IA? Ça, c'est une question qu'il faut poser lorsqu'il y a des discussions au sein des directions et avec les syndicats. Est-ce que l'entreprise utilise l'IA? Oui. Alors, si oui, c'est une nouvelle technologie. Vous devez m'informer, me consulter sur les conséquences positives, probablement, mais aussi quels pourraient être les risques et pourquoi on doit utiliser cette technologie avec quelle finalité. Donc, dans mon bouquin, il y a aussi un petit peu ces conseils simples pour essayer de démystifier les sujets, pour dire il y a ces sujets, on a des leviers et des outils qui peuvent être d'ores et déjà utilisés pour négocier aussi sur l'intelligence artificielle. Et il y a aussi une directive européenne qui est traduite aujourd'hui, devait être traduite en loi dans tous les 27 pays membres, qui est la directive sur les lanceurs d'alerte. Et les lanceurs d'alerte, avec les syndicats, parce que les syndicats sont protégés, sont considérés des facilitateurs qui peuvent aider les lanceurs d'alerte, peuvent lancer des alertes sur un usage inapproprié de la surveillance, sur un usage inapproprié des données personnelles, etc., etc. Donc là aussi, c'est heureusement un instrument que nous avons en Europe. Je dis ça parce que ce n'est pas parce qu'une loi existe ou des règlements existent que nous les faisons vivre. Mais ces instruments sont là. Peut-être il faut davantage que les syndicats connaissent. Et l'opportunité que m'a donnée la publication de mon livre en France, c'est qu'aujourd'hui, j'ai fait les tours des fédérations. Je pense que c'est très positif parce que ça veut dire que les fédérations dans tous les secteurs, au niveau de ma confédération, sont en train de s'approprier et de vouloir comprendre ce sujet. Et donc, je pense qu'il y a besoin de cette formation, de cette sensibilisation. Donc, je pense aussi que cette première initiative d'ETUI participe de cette prise de conscience. Donc, les négociations, pour la plupart, sont absentes. Donc, je pense qu'on a une stratégie maintenant politique à mettre en place. La formation, je l'ai déjà dit, démystifier les sujets. Parce que si on les rend davantage compliqués, on parle que des algorithmes, on est désemparés vis-à-vis de beaucoup de militants. Et donc, donner les clés pour interpeller les directions. Les outils juridiques, ça m'étend, mais aussi une série de questions simples qu'on peut poser au niveau des Work Council, en France, des comités socio-économiques ou des conseils d'administration. Nous avons aussi des élus au conseil d'administration. Et en France, la loi sur les conseils d'administration prévoit que si une entreprise a une stratégie sur l'intelligence artificielle, donc ça c'est un peu limitatif, mais les élus peuvent l'interpeller au niveau du conseil d'administration pour dire quelle est votre stratégie, pourquoi elle est utilisée, quels sont les impacts sur le travail notamment, parce que c'est de ça dont il s'agit, et comment vous allez l'introduire, quel design vous avez mis en place, est-ce qu'il y a une implication des acteurs, des métiers, etc., qui sont touchés peut-être par l'intelligence artificielle et comment on anticipe ces genres de changements. Donc, je pense que c'est des clés que nous devons un peu divulguer et avec un travail un peu commun, peut-être, mais des sensibilisations qui doivent être très fortes. Ensuite, il y a d'autres opportunités. Aujourd'hui, je participe aussi à la conférence pour l'avenir de l'Europe. Elle se réunit encore demain à Strasbourg. Je participe dans un groupe de travail sur le numérique, où il y a les citoyens qui parlent, mais il y a aussi la société civile organisée, dont je fais partie. Et donc là, on insiste pour dire que dans les conclusions de cette conférence, il faut mettre vraiment l'accent sur d'abord la façon dont cette technologie est utilisée et comment l'humain doit rester aux commandes, doit avoir les derniers mots. Et enfin, les bonnes pratiques, peut-être quelques exemples en France. Donc, d'abord, la diffusion d'un guide, c'est utile. Les webinaires participent aussi de cette divulgation. Des séminaires, des accords. Alors, les accords, il y a beaucoup d'accords sur lesquels travailler. Il y en a 3000 en France. Beaucoup contiennent aussi quelques droits, quelques aspects sur les droits de déconnexion et sur l'équilibre vie privée et professionnelle. Peu encore concernent la question du contrôle, par exemple. Mais voilà, c'est un sujet à part entière. Les branches, il y a la branche des assurances et des banques, qui, dans son observatoire des métiers sur l'évolution des métiers, a dit que aussi l'intelligence artificielle pour anticiper ses effets. Donc, une petite référence au niveau de la branche. L'ACNAM, qui est la Caisse nationale d'assurance maladie, a mis en place, via notre syndicat, une commission sur les contrôles des données, de l'utilisation des données aussi pour les données sensibles concernant les patients et les citoyens. Donc. Et voilà, donc c'est des exemples. Mais je pense qu'on n'est qu'au début, hein, Philippe Pochet l'a dit, on est au début de cette trajectoire. Nous sommes en retard, peut-être parce que tous ces outils ou ces technologies sont déjà à l'œuvre, mais cette fois-ci, il ne faut pas rater les trains parce que nous ne pourrons pas venir facilement en arrière une fois que des attentes ont été faites, si nous n'arrivons pas à réguler. Et il y a aussi, last but not least, la régulation européenne sur l'intelligence artificielle basée sur les niveaux de risque qui aujourd'hui néglige beaucoup le monde du travail. Et donc là-dessus, je sais que la Confédération européenne des syndicats, je participe aussi dans le groupe ad hoc que la Confédération a mis en place, il y a quand même la question du travail qui doit devenir aussi une question importante dans ces règlements. Aujourd'hui, elle est assez négligée, marginalisée. Merci pour votre attention et à votre disposition.
Thank you so much, Franca. And I won't make many comments because we don't have much time left. And I do want to get to the questions that we have in the chat or the Q&A. And please do continue to add your questions. The speakers can answer them individually, or we'll hopefully have time to add a few. So there's, I think, one theme, important theme I see coming out from the session, and then perhaps a question of my own for the speakers. I think the main theme that I saw running through these presentations, but also the earlier ones, concern the importance of different laws or legal frameworks and court decisions in each country. Particularly in Italy, court decisions become quite important, and how these then provide distinctive tools for unions, perhaps that they're just starting to recognize and actually use. We've heard across the presentations data protection rules, or GDPR, one important tool, but also co-determination and consultation rights over introduction of certain categories of technologies to monitor workers or those that pose risks to employee health and security. And I think this raises the question that is perhaps beyond just answering it in the next 10 minutes, but I think that all of the panelists addressed already in their presentation, that really what unions are struggling with right now is how to really exchange these experiences and figure out how to actually recognize these national legal frameworks and rules, while also exchange best practices across countries with very different frameworks, right? We see that with Birte trying to create a kind of data bank and understand the framework across different national contexts. I think this is particularly important to figure out how to mobilize these experiences and really encourage legal reforms at the national and EU level that are supporting strengthened worker voice in the adoption and deployment of these technologies. And a second question that I have, I already talked about this a bit with the panelists when we were preparing for this session, and it really comes from my own research in the ICT industry. And I've been studying, the adoption of AI, but algorithmic management is just part of that. So there are distinctive issues from the use of AI in algorithmic management, monitoring and management decisions on the one hand, versus the use of AI to monitor and automate jobs on the other. And these two are often closely connected in service industries where you all are focused, or the industry base that you're in. So for example, robotic process automation and chatbots use AI to perform jobs that were previously done by contact center agents or back office service workers, but algorithmic management is also automating and changing the content of management jobs. And these, of course, are also issues that your unions are negotiating over. So this may be another reason why the use of AI is such an important issue for unions in many service industries, but I think it raises this question of how your unions address these kinds of linked employment and job quality impacts, right? So often algorithmic management is not the only use of AI, and unions are very focused also on how to think about what the employment impacts of these technologies are going to be. So I will leave those as kind of a starting point for responses from you all, and then we'll move on to questions. So perhaps if Birte wants to start off.
Okay, I can start. I mean, you actually kind of answered yourself already when putting the question out there, but basically, I can't agree more than with what Cinzia and Franca have already been saying. It's very much a question of using the tools that are already out there, partly, and negotiating new agreements. So it's a two-way road. Actually, there are different elements, I think, of what the mission of unions should be at the moment. The first is really awareness raising, and there we've been saying that good material is already being prepared, but it needs to be really trickling down from the different levels to the shop floor, and really information and training of the workers and their representatives to really understand the issue is key. I think there is a huge work for trade unions at national level, and it has been starting out, but there is still a lot more to do. So I couldn't agree more, and I really welcome these kind of guidelines issued by several unions. This is really important work. And in terms of exchanging that experience, this is what the ETUI is for, this is what Union Europa is for. The European level federations and institutes are the forum that can help facilitating that work and really help the exchange. And I think these kind of projects, but also our day-to-day work of Aida, myself, etc., this is really what should help the local and national level organizations and understanding that they are not alone in this, that everybody is facing that issue, and that we can exchange on best practices and put them into use. And I think this is also a mission and something that is definitely our strategy for the coming term. And regarding the question of automation and the services sector, I think it strikes me very much that though AI as such is a cross-sectoral issue, it's really relevant for all workers and citizens, for everybody. It is in Uniropa, at least I can speak for us, the ICT sector and the finance sector are those that are mainly leading on the issues. So I know that discussions have come up in the care sector, for instance, when you look at the use of AI in health, in care. Obviously, other sectors have been dealing with that in transport, energy, and so on. But for the services industry, I think what is interesting is that, and Franca has been talking about that, it's not only the back office automation, that we've been seeing that for a couple of years already. It's not so new. It's actually management experiences, middle management that is seeing their skills and their experiences actually taken off them and being replaced by fully or partly automated decision making at work. And so I really would like to highlight what Franca has been saying, that it's not only the back office, it's management that we talk about that is experiencing that kind of automation that we haven't seen before. And that is new in a way. I think that is really a paradigm shift we should really acknowledge. It's really important. And why the service industry? Probably ICT, obviously, we are the tech affinity sector. We have been launching those products before. They are the first people to run and try out these softwares, for instance, but also the finance and the tech industry are those areas where you have a lot of chatbots, etc. You said it yourself, Virginia, that are being used for already some time. So people have been used to working with those instruments for a while, and that's why they were the first also to start asking questions. And that's probably why when we see the need of these sectors in that area, where that comes from. So that's at least my informed guess. And that leads us also to the question of skills, because that's a topic we didn't mention here before. There wasn't time for that. But the whole discussion is also linked to not only awareness raising and information, but also to how does that affect the whole labor market situation, the job profiles, and what does it mean in terms of training people to keep their jobs? Because the problem with algorithmic management, but AI as a whole, is that when we look into also the European Commission and their funding scheme, this all goes into very high-skilled, high-developed competences like cyber surveillance or data mining or whatever, but people that are already in employment and that have experiences in their jobs and that are facing a certain degree of automation of their skills, they would need our support to move on to the next step and to identify what those skills changes are, and matching them and providing that training is yet another huge demand and role for the trade unions to get involved into the issues. So the whole negotiation agenda that you already have established for a long time on skills can be translated into integrating the whole topic of algorithmic management and AI. So it's another way of appropriating a very complex and difficult subject by using what you've been doing already as trade unions. You've got that experience, use it, and just add on that different layer, if I can say so.
So we're already at 4:20, and I did promise that we would give our translators a break, but I want to give a few minutes also to Cinzia and Franca to give their responses. And you also can see the questions in Q&A if there are any questions in there that you would like to answer. I can quickly say that there was a question about the productivity score introduced by Microsoft in MS365. And when I've been doing interviews with works counselors in Germany, that's actually been a huge topic of co-determination and attempt to negotiate over that. But I will turn it over to Cinzia.
Ok, sì, le domande le abbiamo sentite e io direi che abbiamo due ordini di problemi. Uno che al di là delle differenze di modello sindacale che sicuramente ci sono in Europa, noi dobbiamo trovare punti di convergenza, momenti e occasioni in cui questa contrattazione dell'algoritmo e questo spazio alla rappresentanza di lavoratori e lavoratrici, ma anche di cittadine e cittadini europei, possa essere condiviso e quindi si possa addivenire ad una regolamentazione comune. Tutti noi abbiamo parlato del regolamento europeo sulla privacy, vuol dire che una norma che regolamenta lo spazio europeo ed è uguale per tutti, ha concesso a tutti noi sindacati di agire. Prima si citava l'articolo 22, anche noi lo abbiamo utilizzato per dire devi informarci se c'è una decisione automatizzata, in quanto cittadini, in quanto lavoratori. Poi c'è un ruolo che dovrebbero svolgere i CAE, cioè quello è un luogo, secondo noi, in cui il diritto di informazione e di consultazione preventiva, specie quando lì si applicano o si decide di applicare tecnologie e magari meccanismi di intelligenza artificiale che possono determinare automaticamente, ad esempio, se una grande multinazionale mantiene o meno uno stabilimento in Francia o in Italia, se lo sposta in Germania o in Spagna. Ecco, in quel luogo le rappresentanze sindacali, con uno spirito, diciamo così, unitario, dovrebbero poter aver conoscenza di quello che accadrà. Io faccio sempre un esempio quando parlo di intelligenza artificiale. Se una multinazionale con sede magari extraeuropea non utilizzasse un sistema di intelligenza artificiale che determina la produttività degli stabilimenti in base alle presenze e non fosse educato nel suo data training, diciamo così, sul fatto che in Europa esistono leggi di tutela della maternità e della paternità, forse considererebbe gli stabilimenti europei meno produttivi di altri. Ecco perché noi dobbiamo sapere anche a livello, diciamo così, internazionale, in questo caso i CAE sono ovviamente europei, qual è il sistema algoritmico, qual è il sistema di intelligenza artificiale che viene applicato. Poi ci va un sistema di presenza del sindacato in tutte quelle fasi in cui la tecnologia certifica. Anche qua faccio un esempio e vado così a chiudere. Se molte aziende, molte realtà utilizzano il sistema della blockchain per certificare alcuni passaggi, certificando orari, certificando formazione, cioè la utilizzano come registro di pratiche che sono figlie, ad esempio, di accordi sindacali. Ecco, il sindacato, secondo noi, deve essere un blocco di quella blockchain, deve poter vedere le transazioni che circolano dentro a quella catena. Cioè bisogna che anche noi in qualche modo entriamo a far parte del processo di controllo e di monitoraggio della tecnologia. È molto poi semplice e banale, tutti noi siamo a questo punto direi esperti del sistema. L'intelligenza artificiale, è uscito anche un libro molto di recente, tante volte è poco artificiale, molto umano, no? Quindi ci sono molti elementi di intervento umano nell'intelligenza artificiale. Ecco, noi vorremmo essere la parte a livello Europa che determina uno spazio europeo in cui si possano avere regole comuni, agibili e in cui il sindacato tutto gioca la sua parte, già a quel livello. Poi, tanto più si riuscirà ad uniformare a principi comuni la legislazione e la contrattazione di ciascun paese, tanto più facile sarà condividere pratiche comuni.
Okay, great, thanks. I really apologize for going over a little bit, but I do want Franca to have the final word, so you have a few minutes.
Merci Virginia. Alors, première chose, être conscient que l'intelligence artificielle est avec les travailleurs. Ça semble une banalité, mais aujourd'hui, l'intelligence artificielle, elle est attendue par les employeurs en termes de productivité, des gains, des réductions des coûts, etc. Aujourd'hui, donc, prendre conscience que cet aspect a à faire avec le travail, qui est une dimension qui a été négligée, je dirais. On a parlé des droits des citoyens en général, mais sur le travail, peu. Donc, je pense que même les syndicats doivent être conscients de ça. Je prends un exemple pour me référer au secteur des services. Par exemple, les robots Watson qui sont utilisés dans des banques en France produisent du temps libéré. Parce que, par exemple, ils analysent les mails et répondent aux questions les plus routinières des clients. Et du coup, il n'y a pas un humain qui fait ça. Et alors, qu'est-ce qu'il devient, ce temps? Et là, c'est une négociation aussi syndicale. Il y a des banques qui réduisent les emplois et d'autres qui utilisent ce temps pour améliorer les compétences des métiers, des travailleurs qui occupent des métiers, et pour rendre un meilleur service aux clients. Donc, ce n'est pas les mêmes résultats pour l'emploi. L'autre chose, et je termine là parce que c'était assez exhaustif tout ça, il y a les chantiers qui ont commencé en France avec les ministères du Travail sur l'intelligence artificielle, les numériques et les travail, justement. C'est un chantier qui a été lancé en novembre. Je pense qu'il y a un peu l'équivalent en Allemagne, mais les syndicats doivent être partie prenante. La CFDT a déjà pris contact avec les ministères et les cabinets en partenariat qui travaillent là-dessus. Et ce que je veux dire, c'est que lorsqu'on utilise des logiciels ou des machines, on peut imaginer qu'ils peuvent être conçus au niveau social, c'est-à-dire ce qu'on appelle le social design. C'est une application, lorsque j'introduis des logiciels, j'implique mes salariés, mes travailleurs, et donc je les fais participer à la future utilisation de ces machines et coopérer et anticiper aussi les dysfonctionnements ou les dérives. Ça, c'est une approche que nous devons préconiser. C'est un projet européen que ma fédération de la métallurgie dans l'industrie a initié, mais je pense qu'il faut cette voie-là, le design social des machines d'intelligence artificielle introduites doivent être absolument poursuivis, ces chemins. Donc voilà, je m'en arrête là.
Okay, well, we've gone to the very end of our session, so I will thank you all for joining us, and thank you to our excellent guest speakers for really stimulating presentations. And I look forward to the next group of presentations in the next session.
Good afternoon, everyone. Welcome to the final session of this conference. I'm Simon Taas. I'm of the Institute for Labor Law of the KU Leuven, and I will be chairing this final session. For this final session, we can hear some of the experiences on algorithmic management of trade unions in Spain, Germany, and France. So this session is very promising with interesting speakers who will explain whether and how national legislation and collective agreements in their countries address the risks related to algorithmic management and what role trade unions can play in this regulation of algorithmic management. We're a little bit behind schedule, so I think we will just start quickly. Just what I want to say is that if you have any questions, comments, or reflections on the presentations of the speakers, please do type them in the Q&A box, not the chat box, but the Q&A box. And please post them in English because there is no interpretation of written questions. Without further ado, I want to briefly introduce our first speaker. This is Ruben Rans. Ruben is the coordinator of the UGT division specialized in platforms, and he will focus his presentation on the Spanish so-called Riders Law, and he will also explain his experience with the collective agreement that UGT negotiated with Just Eat. Ruben, you have the floor.
Muchas gracias, sobre todo por esta invitación y por darme la oportunidad de compartir con el resto de los sindicatos nuestras experiencias sindicales. Voy a intentar no repetir información que ya se ha dicho. Voy a compartir pantalla para la presentación y perdón, no sé si la estáis viendo.
Yes.
Sí, bien, pues creo que el tema importante que me gustaría trasladar antes de meterme en la cuestión técnica de la negociación colectiva es que estamos ante un modelo económico que se basa fundamentalmente, perdón, en que las plataformas digitales se establecen como intermediarios y crean una expectativa en la que generan una idea en la que tienes que ser tu propio jefe, vas a ganar el dinero por ti mismo y sobre todo vas a hacer crecer tu negocio. Perdón, ¿en qué momento más oportuno me ha entrado la tos? Bueno, le voy a dar una... me parece importante este detalle porque esa es la idea con la que generan la competencia constante y quieren tener siempre una ventaja competitiva con el resto de las empresas. Voy a dar un dato sobre España. En España actualmente hay 10.500 empresas que se consideran startups o empresas emergentes. De estas 10.500 empresas, 9 de cada 10 no aguantan 3 años. Esto es un tema importante. En España existen 11 empresas unicornios y el 18,5% de la población, según el Banco de España, yo pongo en duda esta situación, pues se dedica al trabajo en plataformas. El 50% de la población activa durante el 2020 trabajó a distancia. Evidentemente, la pandemia fue un elemento fundamental que hizo crecer esta situación. Bien, las plataformas más importantes son las de transporte y han generado un verdadero problema, sobre todo con el tema de los falsos autónomos, pero no solo ellos. Aquí tenemos un ejemplo de una empresa de cuidado de mayores en la que establecen la obligación de que la familia contrate al cuidador. En este caso es un anuncio de trabajo para una persona mayor de 88 años con demencia senil y que hay que realizar control de medicación, limpieza del hogar, movilidad, supervisión, cambio de pañal, higiene, preparación de comidas, paseos, un montón de cosas por el salario mínimo. Evidentemente, esta es una situación legal también en la que estas empresas se establecen como intermediarios y no solo son las únicas plataformas que hay otras como puedes conseguir un abogado, un psicólogo o incluso empresas de trabajo temporal que ahora van a tener, esta está especializada, Linkers, concretamente en hostelería, y van a tener un problema concreto, que es que con la reforma laboral, con la modificación de la reforma, ya no pueden tener, el contrato de obra y servicio ha desaparecido. ¿Por qué hablo de esto en concreto? Pues por una situación muy concreta. Nos genera esto unos nuevos retos en la negociación colectiva. Entonces, desaparece el lugar del trabajo tradicional, tu casa se convierte en tu lugar de trabajo o toda la ciudad es el lugar de trabajo. Para eso nosotros lo que estamos trabajando, y por eso estaba explicando antes qué sectores estaban siendo perjudicados, nosotros lo que hacemos es detectar las empresas en función de su actividad principal para aplicarles el convenio sectorial. Esa es nuestra idea. Y por ello lo que nosotros estamos planteando es que hay que abrir los ámbitos de negociación, es decir, aquellas empresas a las que se destina el convenio colectivo y los trabajadores y trabajadoras afectados por ese convenio, hay que ampliarlo para que no exista ningún tipo de vacío legal, porque estos, como se consideran intermediarios, consideran que no les refleja la actividad del convenio sectorial. En aquellas empresas que realmente generan una actividad nueva, entonces sí que se hace un convenio sectorial. Este es nuestro trabajo como sindicatos y así lo estamos haciendo de forma coordinada en acción sindical. Pero también tenemos que evitar la huida de la relación laboral. Hay una serie de factores que a mí me parecen fundamental para esto, que es el tiempo de trabajo. Globo, Globo y todas las plataformas digitales que la Inspección de Trabajo tuvo que darles de alta, la Inspección de Trabajo tuvo un problema concreto, que es establecer su jornada de trabajo. ¿Por qué? Porque las plataformas solo habían tenido en cuenta el tiempo en el que se trasladaban a llevar un pedido. Todo el tiempo de espera no lo consideran trabajo efectivo. Y ese es otro de los elementos también a tener en cuenta, es cómo se considera el tiempo de trabajo. Y no podemos permitir que se pierda el concepto de trabajo por hora para pasarlo a trabajo por tarea. También tenemos que trabajar en la ampliación de los derechos, fundamentalmente porque toda esta inteligencia artificial, los algoritmos van destinados a la creación de perfiles. Los perfiles son los que permiten a la inteligencia artificial repartir toda la actividad. Entonces, bueno, en ese aspecto nosotros ahí hay un reto para la negociación colectiva. ¿Para qué utilizan los algoritmos? Como esto ya se ha comentado, yo no voy a insistir en ello, pero sí que os muestro aquí la foto de un almacén de Amazon en España con falsos autónomos, y lo que explicaré es que España, recientemente, la Agencia Española de Protección de Datos ha sancionado a Amazon por vulnerar el derecho a la intimidad de estos falsos autónomos, porque les exigía subir un certificado de ausencia de penales. Es decir, que no tuviesen ningún delito. Eso es algo que aquí en España solo se puede pedir para ciertas circunstancias muy concretas, como el trabajo con menores o para trabajar en la administración pública o en seguridad, porque si no, no se permite la reinserción de las personas que han tenido algún delito. ¿Por qué digo esto? Porque la Agencia Española de Protección de Datos le solicitó a Amazon que anulara todos los certificados que habían subido a la plataforma. Pero resulta que estos datos estaban en una empresa de Amazon, del grupo Amazon, en la India. Bien, Amazon no pudo certificar que había eliminado estos datos. Por eso fue sancionado con 2 millones de euros en España. Por eso y por vulnerar el derecho de la intimidad. Pero fue un elemento que agravó esa situación. Voy a hablar de la ley Rider. Bueno, en el tema de Amazon hay que preguntarse qué va a pasar con nuestros datos cuando la empresa los sube a una nube. Y creo que esto es otro elemento importante de la negociación colectiva. La famosa ley Rider, mal llamada ley Rider, porque no es solo para riders, pero bueno, se ha conocido así. Nosotros la conocemos como la ley 12/2021, establece la presunción de laboralidad fundamentalmente para los trabajadores de plataformas digitales de reparto, porque era aquí donde se había generado el mayor conflicto. Lo que hace es una mención específica en el estatuto, en una disposición adicional, porque ya existe la presunción de laboralidad. De hecho, lo deja bien claro la sentencia del Tribunal Supremo de, el 25 de septiembre del 2020, en una sentencia contra Globo. Esto modificó el planteamiento inicial que se iba a hacer con la ley, y se demostró que no era necesario un cambio legislativo profundo, sino que la actual legislación era suficiente. Lo único que había que hacer era reforzar, en este caso, la presunción de laboralidad, y se incluyó un artículo en el derecho de información para los comités de empresa que tuviesen acceso a los parámetros que establecen la organización de trabajo con algoritmos. Esta información es un derecho que se hace extensible a todos los comités de empresa y, bueno, pues a partir de aquí pensábamos que íbamos a tener una oleada de preguntas por parte de los comités, pero todavía no es así. De momento, en lo que se refiere a la gestión algorítmica, el primer acuerdo en el que hemos entrado en profundidad sobre este tema ha sido el acuerdo de JASTIC. Es un acuerdo laboral firmado por los sindicatos Comisiones y UGT y con la empresa JASTIC, en la cual la empresa se compromete a informar a todos los trabajadores de toda la inteligencia artificial que hay a su alrededor. Este nos parece un elemento fundamental porque aquí también existía mucho teletrabajo y también se compromete a la eliminación de los perfiles de los trabajadores. Con esto evitamos la competencia entre ellos y sobre todo que los trabajadores sean valorados de forma subjetiva por clientes o situaciones excepcionales que ellos no tienen por qué. Puede existir un perfil por parte del trabajador, pero no será por cuestiones subjetivas ni por la inteligencia artificial, ni el trabajo será repartido por una cuestión de perfiles. También se establece un canal de comunicación dentro de la propia plataforma entre los trabajadores y los sindicatos. Sobre todo, esto está pensado para evitar el aislamiento que tienen algunos trabajadores porque no tienen centro de trabajo. Hay multitud de trabajadores desplazados, en el caso de JASTIC, que con su vehículo trabajan en una zona determinada y cuando acaban el día vuelven a su casa. Y lo que se puede considerar centro de trabajo es el teléfono móvil. Bueno, pues para que tengan el derecho de información tienen que tener acceso desde la aplicación de la empresa, acceso a la información por parte de los sindicatos. Esto aparece también en el texto de la directiva y nos parece muy importante. También se crea una comisión de algoritmos dentro entre los representantes legales de los trabajadores, la gente del comité de empresa, algunos de ellos, y las personas que controlan directamente los algoritmos en la empresa, para que discutan y entre ellos puedan establecer cómo funcionan los algoritmos y cómo debe cambiar. Hay una cuestión que siempre, desde que apareció la ley Rider, me han preguntado multitud de compañeros sindicalistas de otros países y no les sabía responder. Me preguntaban qué tipo de información les tenían que facilitar la empresa respecto a los algoritmos. Bien, nosotros hemos tenido que consultar a expertos y hemos propuesto este texto para la directiva, que el martes tuvimos una reunión con Ludovic y con el resto de los sindicatos y le presentamos este texto con la idea de que pueda ser útil al resto para saber qué tipo de información concreta y específica hay que pedir. Entre ellos, el programador, desarrollador e implementador del sistema. Descripción del tipo de sistema. Bueno, léanselo, yo se lo puedo pasar, pero por no alargar el tema. Hay un tema también importante que son las auditorías. Y en el texto de la Directiva Europea de Plataformas Digitales se habla que estas auditorías serán gratuitas a partir de empresas con más de 500 trabajadores. A nosotros esto nos parece un error. Más de 500 trabajadores lo que va a permitir es estas plataformas que tienen la posibilidad de externalizar la actividad, de generar otra serie de conflictos bueno, pues no puede ser que la auditoría sea a partir de 500 trabajadores. Esperamos que este parámetro se reduzca y al menos se baje, si no se elimine, porque el derecho no se puede limitar a un número de trabajadores, si al menos se baje de forma importante a 50, creemos. ¿Por qué hemos presentado este texto? Nos lo decían los expertos. Hay que intentar traducir al algoritmo de forma sencilla, de tal forma basada en la idea de los prospectos médicos. Cuando vamos a la farmacia y compramos un medicamento, tenemos siempre una información porque es un producto altamente peligroso y los algoritmos son altamente peligrosos. Hay que considerarlos como de alto riesgo. Entonces tienen que darte una serie de recomendaciones, especificar cómo deben de ser, y esta es la idea que nosotros trasladamos aquí, que se considere como un prospecto. Mi compañero José Varela, también de UGT, escribió un estudio que se llama Las decisiones algorítmicas en las relaciones laborales y explicó cómo debería de ser el proceso de negociación en el cual hay que implementar los algoritmos en la empresa. Yo se los dejo, creo que es una forma muy sencilla para hablar de negociación de algoritmos en las empresas, pero sobre todo lo que creo importante es que antes de empezar a negociar hay que plantearse si es necesario incorporar algoritmos e inteligencia artificial a la empresa. Y fundamentalmente, una vez que acabe esta situación, hay que hablar de la plusvalía que genera la incorporación de algoritmos en la empresa para que reviertan en beneficio también de los trabajadores. Cuando antes decía que existían 11 unicornios en España, esos unicornios, esas empresas tan especiales, tienen una valoración en el mercado de más de 1.000 millones de euros, pero no generan beneficios. Lo único es que tienen una valoración tan alta gracias a los datos que manejan. Y esa es la plusvalía que generan los algoritmos y que también tiene que repercutir en el beneficio de los trabajadores. Además de esta fase de la negociación que estábamos hablando, también planteamos una ley de justicia algorítmica en las relaciones laborales que garantice la transparencia. Ya lo han mencionado antes, yo no voy a repetirlo. Pero sobre todo hay un planteamiento que también hemos introducido en la directiva europea, que esperamos que se acepte, que es el registro de los algoritmos laborales. Evidentemente, sin el registro no vamos a poder saber si los algoritmos tienen una trazabilidad y si son transparentes y sobre todo si se han modificado o no se han modificado. Este es un elemento que nosotros en el momento de la ley Rider expusimos, pero generó un gran conflicto en la patronal porque pensaban que iban a tener que enseñar el secreto de la Coca-Cola, por decirlo así. Y no es eso. El registro de los algoritmos laborales, lo que nosotros buscamos no es saber qué es lo que le hace maravillosa a la empresa, sino evitar que se realicen sesgos que puedan vulnerar derechos fundamentales. Insistir que es de alto riesgo, y sobre todo insistir también en que corresponde a tomar la decisión a las personas, en último caso. No sé cómo voy de tiempo, pero si me permitís un ejemplo muy sencillo de un comité de empresa que nos expusieron un caso, es una empresa que se dedica al reparto de comercio online y diariamente realiza más de 100 rutas diarias. Esas 100 rutas se realizan con algoritmos. ¿Cuál era su problema? Que los datos con los que hicieron las rutas en su momento no eran de calidad. ¿Por qué no eran de calidad? Porque lo hicieron durante la pandemia. Entonces no había tráfico. Se llegaba a los sitios rápidos. Por tanto, los datos que se cogieron en aquel momento no eran reales. Y entonces los compañeros del comité de empresa lo que me decían era que querían introducir parámetros en los algoritmos sobre dificultades para aparcar en ciertas zonas de Madrid. Si el edificio tenía ascensor o no tenía ascensor, si había un colegio cercano, porque esos son parámetros que se pueden establecer dentro de los algoritmos para establecer las rutas. Por eso es tan importante la participación de los trabajadores. Es ahí donde nosotros queremos incidir, porque esto también va a mejorar la productividad, pero sobre todo lo que va a hacer es garantizar que no nos vulneren derechos fundamentales. Por último, respecto a la directiva europea, lo que me gustaría es que esta directiva fuese capaz de acabar con el discurso que existe entre relación laboral y trabajo autónomo. Esta dicotomía enfrentada, que creo que no existe, pero que hay que evitar que se desdibuje la línea que los separa con los indicios fundamentales de quién es el que organiza el trabajo y quién se lleva el beneficio de ese trabajo, ¿no? Fundamentalmente los algoritmos gestionan eso. Por eso es tan importante la negociación colectiva. Y insistir que el trabajo asalariado, el trabajo por cuenta ajena, es el que ha permitido la construcción de la Europa social, el reparto de la riqueza, y que debemos combatir aquel discurso que nos decían al principio del éxito y de hazte, sé tu propio jefe, todo este discurso que al final lo que provoca es desigualdad, como ya hemos visto en el caso de las plataformas. Quisiera terminar con la frase del Quijote de Miguel de Cervantes, cambiar el mundo, amigo Sancho, que no es locura ni utopía, sino justicia. Lo hago por un tema personal, porque cuando voy a recoger a mi hijo, cuando iba a recoger antes a mi hijo en el colegio, veía siempre esta frase en su clase y realmente creo que esa es nuestra función y que los sindicatos tenemos que ser la vanguardia para cambiar el mundo, para que no decidan sobre nosotros cómo tiene que ser el futuro. Nosotros somos los que generamos el futuro. Muchísimas gracias.
Thank you very much, Ruben, for this very interesting presentation. I think we will need to go on to our next speaker. So if you have any questions, perhaps we can discuss them after the presentations. Our next speaker is Johanna Wenkebach. She is the director of the Hugo Zinsheimer Institute for Labor Law of the Hans Böckler Foundation, and she will explain the experience regarding algorithmic management in Germany. Johanna, the floor is all yours.
Yes, thank you for inviting me and for all the very interesting presentations during this afternoon. I learned a lot, and I can cut some of my parts because actually much corresponds and has been said before. I didn't prepare a presentation, and I will go along the questions that Valerio has been sending me. So the first question was about national legislation in Germany protecting against the risks by algorithmic management. And I think you might be interested in the first important precedent case we had in the federal labor law on actually platform. Romla, you might have it in your countries active as well. And I'm not going into the details of the platform work situation, but what I thought was very interesting, and I was actually surprised that the Labor Court went so far, is that they really focused on the aspect on power used by algorithmic management. And they really got into the details of the impact on the work relationship and on dependency of work, even in a contract situation where people can choose if they want to take over work or not on the platform, that algorithmic management and methods of gamification actually lead to a control that leads to the status of platform workers as workers. And then we have labor law applying, we have protection of the work council applying. So this is very important, I think, for the future of work regarding the basic influence of labor law. And of course, we already talked a lot about data protection. This is what applies in Germany as well. I think health protection is a very important field of regulation for AI, because as we already said today, there's a strong influence on of pressure, and that can lead to especially also psychologic sicknesses. There's first data on this constant pressure of work that's also causing bad sleep and sleeping disorders. So algorithmic management and AI needs to be taken into account from a health protection perspective strongly. And then, of course, we have anti-discrimination rules, very important. But the problems that we see in anti-discrimination law is, of course, the burden of proof and proving discrimination on locked up algorithms is a problem. That's why transparency rules are so important. And then we have co-determination. I will send a link to an open source article I wrote with my colleague Ernesto Klengel on the latest reforms regarding co-determination of algorithmic management in Germany, which I think is worth taking a look at, because it shows that the German legislator focuses on the need to co-determinate algorithmic management in the plans. And especially also they focused on the giant developments in the world of work. And so what they set up, and I think this could be a good example for other European countries as well, the financiation of experts to support labor, like works councils with IT specialists, and this must be financed by the employer, because it's logic that you can't really judge on which impact will AI have on the workforce without the help of such experts. So what they set out in the Works Council Modernization Act from just last year is that the employer has to provide finance of such experts. And I think this was a good step forward, but in our opinion, it's not far enough of what we need to actually deal with AI in the world of work by labor law. So this was just a first step. And of course, we have a problem with what many colleagues said before, the representation of workforce by works councils. This is a set up and very successful system in Germany. You know that the works councils are not labor unions, but they have rights for co-determination. Of course, they are exchanging with labor unions, so they are taking care to enforce collective agreements and to enforce the law, which is always more effective than having a single person having to enforce the law. But especially platforms and many tech concerns coming from the US, like Amazon that my colleague just talked about, are really, well, we could say standing in a tradition of union busting. And so they also have problems dealing with this system of co-determination, and they try to keep works councils out. We have actually many lawsuits going on with gorillas in the food delivery sector, for example. They lost various trials in labor court by trying to not install a works council. And that's kind of symptomatic for this scene, especially the scene that is very keen to use algorithmic management. Then I was asked how collective agreements or information and consultation rights provide protection in the context of algorithmic management. And I think much of this has been said already this afternoon before, so I'm going to be very short on this. We have first good examples on the plant level of agreed negotiations on how to implement algorithmic management processes, and they have all the features for the risks we see so far, which is the data protection, transparency of AI used, and we also always recommend to, because AI is a moving target. This is nothing you can fix in one agreement and it will stay like this. So we always recommend to kind of agree on the process of applying AI in a company. And we have first examples of this happening. So AI is rolled out in the company. There are rules applying, and after 1 year, the Works Council and the company side, like the management side, come together again to discuss on what was going good, what was going bad, how should the agreement be updated somehow on how the process was going. I think this is something leading to a good way. And there was a question in the questions and answers earlier that day saying, what are you doing to kind of, I think, stop the mistrust in unions against AI? I think actually co-determination is the way. And in the Hans Böckler Foundation, we have data saying that, of course, people, when they feel that their interests matter in the process of digitalization in the plants, they are more open to processes and they have less fear, but they need to be sure that their rights are guaranteed. And so maybe this answers this question from earlier before. What we discuss intensely in Germany is what we we gave this the title transformation, because these processes of digitalization, they come together with the economic transformation of the ecologic transformation of the economy. So this is leading to a major change, and we are not sure about the impact on work. And we do believe that qualification is a key issue for a good process of this transformation. So in our discussions, regulating AI and preventing a bad impact on the workforce is by making sure people are educated in the new fields of work coming up, while automatization is taking away other jobs. And this is a process that needs to be long planned. And this also has to be a process that is co-determinated. And people need time to be educated and trained on their jobs, because we want this to happen before people are unemployed. And actually, the new government has very concrete plans for free working time in order to qualify for shifts coming up through these processes of transformation. Well, and of course, this was said before, the role of trade unions is to network, to bring ideas together, to bring best practice together, and also to do strategic lawsuits in order to clarify the law in unclear situations. And that leads me to my last point, of course, lobby work, because both in platform work and regarding AI, there's new legal frameworks coming up that will really set the rules for the future of work, which is happening now. And I think it's very important to bring, that's why I think it's a great idea to have this discussion today, to bring the perspective of working people into the governing bodies. And regarding the last question I was giving, which is about the directive of platform work, which has a chapter on AI, and what is our opinion about it. We think that this chapter is a very good first step to regulate AI because it has important aspects for regulating AI, which is transparency, but it is also co-determination rights and making sure that both workers, platform workers among each other, and interest groups, workers' representatives, and workers can be connected. And looking at the future of work in especially algorithmic management makes it possible to really divide forces physically from each other. And labor unions need strategies to reach people and to organize people, to organize solidarity in this divided, like physically divided world of work. And algorithms can cut work into very small pieces and hand them out to many people who are not really connected by a company anymore. This is actually really the heart of platform work. So this is raising questions of solidarity and as the source to have collective agreements in the future. And this is why we think this aspect is important, and we're happy that the new government in Germany has a similar right for the working world in general, like digital access of workers' representatives and labor unions to a digitized workforce. They have it in their program for the labor law in the next 4 years. So I hope something good is coming up, because I think this is essential to keep labor unions able to improve working conditions by collective agreements, because solidarity is the source for all of this. I think this is what I would say so far. Thank you.
Thank you very much, Johanna, for this very clear contribution. Perhaps we can discuss these insights a little bit further during our general discussion. For now, I would like to introduce our final speaker of the session, Eric Perez. He is not only the Secretary General of the FO Cadre, but he was also until 2020 the Vice President of the Commission Nationale de l'Informatique et des Libertés. He will give a presentation on the algorithmic management experiences in France. Eric, you have the floor.
Merci beaucoup. Alors, juste une petite correction. Je suis le secrétaire général de l'Union des cadres et ingénieurs FO cadre, et non pas de FO. Premier point. Et j'ai été pendant 10 ans, en effet, commissaire à la CNIL, Commission nationale informatique et liberté, et vice-président, commissaire avec le portefeuille de l'industrie, du transport, de l'énergie et accessoirement aussi la défense. Et donc, c'est en effet un point essentiel qui nous a permis de travailler plus étroitement avec les organisations syndicales sur justement à l'époque ce qu'on appelait les délibérations, les recommandations, mais aujourd'hui sur ce qu'on appelle les référentiels sur lesquels je reviendrai notamment sur l'article 40 du RGPD. Alors, tout d'abord, un grand merci pour cette invitation et l'organisation de cet événement. Et puis, un grand merci également à tous les intervenants pour la richesse et la qualité. Je ne vais pas dire beaucoup de choses puisque, comme ma prédécesseuse, je considère que beaucoup de choses ont été dites et je partage la quasi-totalité de ce qui a été dit. Je voudrais revenir quand même sur 3 grands points. Le premier, c'est d'une manière générale, les organisations syndicales se sont toujours attachés à la défense des conditions de travail, à l'emploi, bien évidemment, dans un cadre historique qui était l'unité de temps et de lieu, et surtout avec la visibilité de l'employeur, de celui qui contrôlait. Or, aujourd'hui, tout est diffus. Et les outils algorithmiques sont aussi une façon de dématérialiser des processus de contrôle, de gestion, et je considère que la définition de management algorithmique est très intéressante dans le sens où c'est gouverné par la donnée. Alors, ce n'est pas nouveau, puisqu'on manage tous par la donnée. On a tous été, à un moment donné, et on continue à le faire, à collecter, traiter des données. La seule différence, c'est que quand on le fait sur des données qui sont des échantillons dont on a considéré quelles étaient plus ou moins les définitions, le cadre, alors qu'avec les algorithmes, nous sommes dans le cadre d'une collecte massive de données qui ne sont pas structurées, et tout ce que nous faisons, tout ce que nous disons, même là, actuellement, tout peut devenir une donnée. Et donc, tout peut être mis en donnée. Donc, c'est le monde qui est mis en donnée. Et lorsque l'on dit cela, cela n'échappe pas au monde du travail, pour la simple et bonne raison que dans le monde du travail, la logique de l'employeur a toujours été aussi de contrôler ce qui était fait, tout ce qui était donné. Dès lors, vous l'aurez compris, avec les données, les algorithmes, les employeurs et les entreprises ont un outil beaucoup plus puissant pour exercer ce pouvoir et ce contrôle. Et c'est pour ça, en fin d'introduction, et je suis tout à fait d'accord avec tous les intervenants, il nous faut recouvrer ce pouvoir d'agir. C'est-à-dire qu'il faut rompre la symétrie qu'il y a entre, d'une part, les employeurs et les informations qu'ils détiennent, et les travailleurs, d'autre part. Ce qui était historiquement dans un temps, dans un lieu visible, aujourd'hui, il est différemment, c'est-à-dire effectivement sur des données, mais à distance. C'est des informations qui vont toucher le recrutement, la gestion, mais pas que. Alors, en même temps, à FO, nous sommes extrêmement partie prenante du progrès technique. Mais nous disons, attention, le progrès technique, il n'y a pas de déterminisme et il faut être capable, dans un syndicat, de pouvoir dire non. J'ai bien aimé quelques interventions, notamment, je crois, celle du camarade espagnol, quand il a évoqué la question de se dire, mais il faut aussi se poser la question de ce qui est pertinent ou pas. Est-ce qu'il est nécessaire ou pas de mettre en œuvre un dispositif algorithmique pour atteindre un objectif, alors même qu'un autre procédé pourrait tout aussi être pertinent et plutôt socialement responsable et plutôt même très intéressant d'un point de vue écologique. Cette question doit être posée et nous devons, nous, en tant que syndicat, nous poser la question. Alors, que faisons-nous? J'y reviendrai tout à l'heure. Dans nos formations, mais d'une manière générale, c'est ma formation aussi de commissaire à la CNIL, tout a été dit. Nous avons tous les éléments, que ce soit la loi en France informatique et liberté du 6 janvier 78, qui est très ancienne, hein, avec également les Allemands, les Italiens, qui est issue d'un rapport Tricot et qui, dès le départ, a défini dans son article 1, qu'on oublie tout le temps dans la loi informatique et liberté, l'informatique doit répondre à la dignité et au respect des personnes. C'est-à-dire qu'on doit toujours se poser la question de la finalité des outils que nous mettons en œuvre. Et c'est pour ça que dans le syndicat, quand nous sommes, nous, dans le cadre de formation et que je forme maintenant les organisations syndicales, les responsables et les délégués syndicaux, je leur dis toujours, avant de partir en guerre, posez-vous et posez la question systématiquement aux employeurs, quelle est la finalité du dispositif que vous nous présentez? Et donc, finalité, il faut qu'elle soit explicite, très claire. Il ne s'agit pas de dire qu'on veut le bonheur du monde, ni le bonheur des salariés, c'est concrètement. Je vais prendre un exemple. Maintenant, c'est passé, Sanofi, à une époque, et on met en place un dispositif. Les salariés ne font pas très attention, mais qui, selon l'employeur, relevait de la sécurité. Mais cette explicitation n'avait pas été très claire. Sauf que ce qu'on s'est aperçu, c'est que l'entreprise avait mis des capteurs RFID dans l'entreprise pour dire, eh bien, si vous êtes plus nombreux dans une pièce, eh bien, le capteur va détecter que le volume, la masse est beaucoup trop importante, donc il y a un risque, et donc il faut sortir de la salle, il faut en trouver une autre plus grande. Sauf que ce que n'avaient pas fait les syndicats, c'est comme ils n'avaient pas travaillé sur la finalité et sur un autre aspect qui est celui de la proportionnalité, quand nous avons travaillé avec eux, on est allé plus loin, on a posé donc des questions et on a posé la question de savoir, mais quelles sont les informations que vous collectez et de quelle manière vous les collectez? Et là, on s'est aperçu que l'entreprise avait connecté les capteurs RFID au badge des salariés. bien sûr, pour pouvoir permettre de savoir où ils étaient. Mais que ces badges, eh bien, on pouvait identifier également les personnes. Dès lors, on a pu très rapidement travailler sur, bien évidemment, un dispositif qui était illicite, d'abord parce qu'il n'avait pas été porté à la connaissance des représentants des salariés, et dès lors, il était extrêmement intrusif et surtout disproportionné. Et j'en viens donc à la deuxième question. Les syndicats doivent toujours aussi se poser la question, est-ce que le dispositif qui est proposé dans la gestion algorithmique ou le management est proportionné à la finalité recherchée? Est-ce qu'on ne peut pas emprunter une autre voie qui est beaucoup moins risquée pour le salarié et pour l'entreprise? En tant que commissaire, j'ai été amené à sanctionner par souvent même en plusieurs millions d'euros des responsables de traitement, bien souvent parce qu'ils avaient méconnaissance de ces éléments d'information. C'est pour ça que je dis aujourd'hui qu'un des leviers, c'est de nous emparer de tous ces outils juridiques aujourd'hui, à la fois au niveau européen, au niveau national dans les États membres, la loi informatique et liberté, les RGPD, et de pouvoir ensuite avancer devant les entreprises en leur disant, à ce moment-là, que faites-vous avec ces outils? Est-ce qu'on ne peut pas faire autrement? Et enfin, la troisième question, est-ce que le dispositif que vous mettez en œuvre est-il sécurisé et est-il loyal? Et quand on dit loyauté, c'est dans notre pays une juridiction, le Conseil d'État, qui a précisé cette notion de loyauté, c'est-à-dire qu'on doit donner aussi tous les éléments nécessaires aux travailleurs pour être informés. Et je pense, sauf erreur de ma part, que c'est une définition de la Cour allemande sur le principe de l'autodétermination informationnelle. Il faut faire en sorte que les travailleurs aient toutes les informations sur l'aspect technique, mais plus encore sur les finalités, les dispositifs qui sont collectés. Parler de la transparence des algorithmes, c'est très intéressant, on en parle tous, mais sérieusement, je doute fort que ce soit suffisant. C'est nécessaire, mais parce que rendre transparent le code, c'est très complexe, et je partage ce qu'a dit la dernière représentante, c'est que très souvent, ce sont des écritures extrêmement complexes qui nécessitent des experts. En revanche, définir quelles sont les natures de données qui sont collectées, comment elles sont collectées, de quelle façon elles sont traitées, ça, c'est tout à fait nécessaire. Alors, vous l'aurez compris, poser la question de la finalité, et en tant que syndicat, c'est notre rôle. Dans le Conseil social et économique, le CSE, dans les instances représentatives, c'est systématiquement poser ces questions et ensuite interpeller, bien évidemment, à la fois les employeurs, mais les interpeller également sur les prestataires. Alors, j'en viens à un autre élément, c'est il y a les entreprises, il y a les syndicats, mais il y a aussi les prestataires, parce que les entreprises sont gourmandes de ce type de dispositif, parce qu'elles pensent qu'elles vont pouvoir minimiser leurs risques, notamment dans le recrutement. L'idée, c'est de se dire, on va faire en sorte qu'on ait le meilleur recrutement, et donc on va capter des données les plus importantes, y compris des données qui n'ont plus rien à voir avec la compétence du travailleur et qui peuvent être des données qu'on va capter sur les réseaux sociaux ou des données qui n'ont rien à voir avec l'élément même de la compétence et de la qualification. Dès lors, il faut aussi s'interroger sur les prestataires qui sont en lien avec les entreprises. Et là, nous avons aussi la nécessité de travailler pour faire en sorte qu'il y ait des référentiels. Moi, je plaide et notre organisation plaide, ça a été dit, il y a un article 40 du RGPD qui est le plus opérationnel, le 88. Pour avoir été pendant 20 ans, j'ai participé à la mise en œuvre du RGPD, qui est une déclinaison, comme l'a dit Franca, du RGPD. Mais l'article 88 nous oblige à devoir faire des propositions. En revanche, dans le RGPD, l'article 40, certes, évoque la question des chartes, des codes, même si nous ne sommes pas forcément partie prenante des codes dès lors qu'il n'y a pas véritablement de contraintes, mais dès lors qu'on associe ces codes de bonne conduite aux dispositions du RGPD et dans le cadre de la loi informatique et liberté française, on peut tout à fait, dans un secteur, déterminer ce qui est bon ou pas bon, ce qu'il faut interdire ou ne pas interdire. Et dès lors que ce dispositif est négocié entre les différentes parties prenantes, il est ensuite validé par la Commission nationale informatique et liberté en France. Si c'est un dispositif qui reste au niveau de l'État, enfin de l'État membre de la France, ça reste dans le giron bien sûr de la France, mais l'enjeu pour nous, syndicats en Europe, c'est de travailler sur des référentiels qui soient certifiés par le DPB, le board européen, pour dire, eh bien voilà, en matière de recrutement, il sera interdit de collecter des informations sur le caractère ethnique. Il sera interdit de collecter des informations biométriques pour apprécier tel ou tel type de comportement. Et donc, c'est à nous de faire des propositions en la matière et nous avons les dispositions juridiques qui le permettent. Et dès lors que le DPB, au niveau européen, considère que c'est quelque chose qui est en adéquation avec le RGPD et répond aux aspirations du RGPD, alors il s'impose à l'ensemble des États membres et à l'ensemble des responsables de traitement. Donc, il y a un vrai travail. Troisième point rapide, parce que je ne voudrais pas non plus trop prendre de temps, il y a 3 grands niveaux d'action. Il y a celui qui relève de la loi dans un pays. Effectivement, ça a été évoqué en Italie. On le voit aussi, nous, on a ces discussions sur la question des travailleurs des plateformes. Et là, je rejoins peut-être ce qu'a dit également le camarade espagnol, notamment sur la question des algorithmes. Il faut que nous, dans notre loi, nous intégrions que la notion de subordination, telle qu'on l'a conçue historiquement, avec un employeur qui donne des décisions, des orientations, eh bien, intègre aussi la notion de parasubordination dès lors qu'elle est en lien avec un algorithme qui va définir quelles sont éventuellement, à un moment donné, les plages horaires dans lesquelles il doit intervenir ou pas. Donc, il y a le niveau national qui définit les normes, les lois. Il y a ce qui relève de la régulation et de notre capacité, nous, d'organisation syndicale, c'est les négociations. Et là, je partage ce qui a été dit notamment sur la capacité de la négociation collective. Attention, il ne s'agit pas, dans le cas de la négociation collective, de mesurer la chaîne ni le poids du boulet. Il s'agit non pas de négocier les libertés fondamentales, elles ne sont pas négociables. Ce qu'il est important de dire, c'est qu'il faut être capable, dans une négociation, de dire ce qu'il ne faut pas utiliser et voire interdire. C'est le cas notamment dans ce qui est proposé par la Commission européenne sur la question de l'intelligence artificielle, avec la notion de haut risque, c'est d'interdire certains dispositifs dans le recrutement, dans la gestion des compétences, dans éventuellement l'évolution des carrières. Et à partir de là, de construire ensemble ce qui peut être effectivement pertinent pour l'entreprise en termes d'innovation et de compétitivité, tout en assurant la protection des travailleurs d'autre part. Alors, pour y arriver, il y a ce niveau de négociation au niveau des entreprises ou des branches. Il est clair, et ça a été dit par Franca, que c'est récent. Nous n'avons pas de négociation tout simplement parce que jusqu'à présent…
Eric, je suis désolé de vous… Il faudrait terminer en minutes, s'il vous plaît, votre intervention. Merci.
Ça tombe toujours sur moi dans les interventions. C'est toujours le cas du dernier. Bon, écoutez, il me reste combien de temps? Combien me reste-t-il de temps? Je pensais que c'était 15 minutes. Allô?
Encore 1 ou 2 minutes, mais il est déjà 17h30 passé.
Bon, écoutez, dans ces cas-là, c'est assez frustrant. Je vais en terminer là parce que je pensais que j'avais 15 minutes. Je vais utiliser les 15 minutes? Non. Bon, écoutez.
I'm afraid so already.
C'est assez dur. Bon, mais c'est pas grave. Je vais continuer sur les 2 ou 3 minutes parce que je trouve quand même que c'est nécessaire. Donc, 3e niveau, c'est bien sûr les négociations. Le 3e niveau, c'est la capacité que nous avons, nous, en tant qu'acteurs, d'agir, y compris en termes de données. C'est-à-dire être extrêmement précis dans la manière dont nous avons également à utiliser dans l'usage domestique professionnel. Et je pense notamment quand il s'agit en termes de télétravail, d'utiliser ses propres outils technologiques pour pouvoir télétravailler. Nous proposons, nous, que ce soit normalement les outils de l'entreprise de manière à ce qu'elle ait une responsabilité. Alors, j'en viens rapidement sur, puisqu'il me reste plus que 2 minutes. Il y a l'accord cadre européen sur le numérique, qui est certes pas forcément normatif, mais qui pose la question effectivement de savoir ce que nous pouvons faire. Nous devons nous en saisir, notamment en France. Il y a l'agenda social des partenaires sociaux en France qui place la question du numérique et de la question algorithmique au cœur de ces sujets. 1, nous devons nous en emparer. 2, nous devons continuer à travailler sur la formation. La formation, c'est la formation des syndicats, des élus, bien évidemment, avec des droits sur l'intelligibilité des algorithmes, la possibilité de joindre les responsables et les concepteurs, mais également la possibilité de former les ingénieurs. Ça a été dit par Franca sur le design, social design, c'est-à-dire comment peut-on aussi agir en tant qu'organisation syndicale. Nous le faisons, nous, au sein de la commission d'éthique des ingénieurs. C'est comment intégrer dans la maquette des formations des ingénieurs cette conception de l'éthique des designs et de la conception de certains outils algorithmiques. Et enfin, il est clair que l'entreprise, et je le dis très clairement, sera extrêmement vigilante dès lors qu'elle saura que les organisations syndicales sont formées, c'est ce que nous faisons avec des guides et des formations, mais dès lors qu'elle saura aussi que si les organisations syndicales sont en capacité de faire en sorte que dans l'entreprise, il n'y a absolument aucun respect ni conformité au RGPD, elle s'expose bien évidemment à des sanctions financières extrêmement importantes. Et le risque d'image pour une entreprise est extrêmement dommageable, donc elles seront amenées effectivement à négocier. Donc oui, je pense qu'il est tout à fait possible aujourd'hui de porter cette question, à condition bien sûr de poser les termes du débat, et les termes du débat, c'est d'associer protection et innovation d'une part. Voilà.
Thank you very much. Sorry that we had to interrupt you, but we are running out of time, and we promised to close the session at 35. But I saw that there are no big questions, so that leaves that I have some time to give a small summarize of this session, because I think the three speakers really showed that there are three different, or you can have three different approaches to deal with collective bargaining and algorithmic management. And if you see the Spanish approach with the rider's law, it's really an act on a specific sector, providing specific safeguards to platform workers. So this is really interesting. And we had the German experience with the Co-Determination Act and the reform on the Works Councils Act. So this is also very important, and we may not underestimate this importance as well. And of course, then we had the data protection view of Eric, and I think it's also very important, and it allows to have a collective bargaining and negotiating on that as well. So I don't think we have time left for some discussions, some questions. If you do have any questions, please post them in the Q&A. I think the speakers will stay a little bit longer, and they can answer them then in the box if they want. I think we will have now a brief break, and then of 10 minutes, and then we will start again at 45. Thank you very much.
You can start because service we don't see.
Yes. That's it.
Okay. Yes, you can start. So, okay. Welcome back, and thank you everybody for being here with us on this last stretch of our event. My name is Aida Ponce del Castillo. I'm a senior researcher here at the European Trade Union Institute, and I work in the Foresight unit, and I'm working on artificial intelligence and data. And I'm delighted to provide the final remarks to this event. And I would like to thank, of course, my colleague Christophe de Gries for having invited me to do so. So thank you very much, Christophe. So my final remarks will be given in 6 main points. Before I start giving my 6 main points, I have to say that trade unions want to be actors on artificial intelligence, but mainly trade unions want to demystify artificial intelligence. And I think that this is one final message that we need to take care. So my first point, it's about risks. So there are numerous risks related to artificial intelligence.
including probably AI-specific related psychosocial risks and probably mental health issues that we need to explore more from a trade union and from a research perspective. They are already being observed in the workplace, in all sectors and in all professions, as the trade unions just mentioned. But my question here, how are we going to assess those perhaps new risks? With what risk assessment framework are we going to do that? Are existing risk assessment frameworks already able to provide some help, or do we need something else? So that's my very big first question related to AI risks. My second question is about addressing AI from a trade union perspective. And here we have observed that not all trade unions and workers' representatives are comfortable to speak or to raise issues about AI in their workplaces. We have seen that there are different views about how trade unions think and approach AI and how to address it, whether it's algorithmic management, data, or IT systems. There are very different ways of addressing it. Hence, this makes social dialogue not an easy topic. But it is not impossible. We have had some examples and agreements, and of course, the autonomous agreements of the European social partners that was signed 2 years ago. Trade unions have to work on implementing that agreement. And my question for this very second point is, how can this agreement, the European Social Partner Agreement on Digitalization, be implemented effectively? Maybe this year already. So with that, I pass to my third point, which is about human autonomy. And here, unluckily, we have entered in an era that we have to defend human autonomy. But paradoxically, human autonomy is a fundamental right. And we have heard from trade unions that autonomy must be a subject of negotiation, which I tend to agree, but it's already a fundamental right. Why do we have to negotiate it in the workplace? Trade unions call that human autonomy human in command or human in control. And my question on my third issue is, what do trade unions have to do to negotiate that autonomy and that control? So now I turn to my fourth closing remark, which is about the leverage that workers have. Well, what do they have? And we have seen many instruments besides negotiation and information and consultation. And we have also seen the power of GDPR. And here I have to give my own appraisal. I'm a great defender of GDPR, and it takes a lot part of my job. And here I have to add a little bit of a promotion of the work that we do here at ETUI, at the research or foresight unit, but also at the education department. We have been working a lot on raising awareness and training trade unions for the last 3 years on how to use GDPR as their negotiating shield. And a publication will come, so please stay tuned. But of course, I'm very happy to know and to hear that trade unions have understood that in GDPR, there is a leverage, but they need to know how to use it. I understand that GDPR is not perfect, but if trade unions do not try it, how would they know that it does not work? So a deep dive on GDPR as a tool for trade unions is one of my personal contributions to the topic. Now I move on to my fifth closing remark, and it's about those key subjects for negotiation. So I think that trade unions that have been sitting on this hybrid table have consigned that the key subjects for negotiation and probably for a future regulation, either in the AI Act or in the directive of improving working conditions on platform work, are the purpose of the technology, whether it's in a machine or in a form of a software, transparency behind an automated decision-making, or transparency behind how a machine operates, intrusive surveillance, including worker profiling, the issue about workers' personal data and how far can it be processed or not, where to put the red lines, if any. But of course, trade unions have also insisted a lot on raising digital literacy, or what I call AI literacy, which is being critically aware and active in discussing AI, and being accompanied by training and skills, which are really critical. And this is already part in the framework agreement and in other collective agreements that we have seen as an example. And I move to my final sixth point, and it's about the EU level. So we have looked at what's happening at the national level, but I have also to say that trade unions at the European level, within whether are the trade union federations or the European Trade Union Confederation, have been very active. And besides signing the framework agreement on digitalization in 2020, ETUC, for example, has just adopted a resolution 3 days ago, literally, on the proposal of the European Commission on the directive on improving working conditions in platform work. Here, interestingly, ETUC proposes a very specific and broad definition on algorithmic management, because ETUC thinks that the definition proposed by the European Commission is rather narrow. And the affiliates have worked on a different definition that possibly could go through into the negotiations. ETUC also raises an important demand, that is the right to information, consultation, participation of workers, and the right to collective bargaining with regards to the algorithmic control. It should be not only granted to platform work, which is the subject of the directive, but also be accessible and be able to exercise by all workers outside the platform work as well. And of course, ETUC has also is working on a position paper on the AI Act and those amendments that should be taken forward by the policymakers, who now are being really discussing the AI Act. So we are entering into a very interesting political debate right now. So my question to the EU level on AI policy making is, will the AI Act and the Platform Work Directive have provisions on the context of employment, or would those be dropped out? And I finish with that very big political question and all the 6 question marks. And with that, I thank you very much for your attention. Thank you for being here with us. I pass the floor to Valerio Di Stefano.
Thank you very much, Aida, for your excellent conclusions. Indeed, your questions lay the path for additional action and research on all of this. And it's important to cite what Philippe said at the beginning of this conference. This is not the conclusion of a project. This is just the beginning of something that we see essential for the future of work, for the future of labor activity, and also for the future of research in these matters. And of course, the ETUI has been at the forefront of this research, and also the work that has been done at the Institute for Labor Law of the KU Leuven, and that now I'm also continuing here in Canada, where I am, has also contributed to shed some lights on what are the risks and the opportunities that come for trade unions from this new phenomena. And of course, this has also been done in a very successful cooperation with the ETUI itself, and we are very, very pleased about it. For me, there's not much left to say other than thanking all the speakers again very much, thanking the ETUI, Christophe de Gries, Philippe Pochet for their support and help, Aida Ponce del Castillo for excellent conclusions, my colleagues Simon Thais and Virginia Dolgast for excellent chairing and moderation of the presentation, and of course Sophie and Maria that helped us with the practical organization of the event. Thank you all very much. Thank you to the speakers. Thank to the audience that has been with us until now. And of course, a huge thank you to the interpreters that really were essential to deliver this very successful event. Thanks again and see you soon.